Uh, Hello.
Sir, please start your presentation.
All right, all right. So, a very good morning to all of you, and I would like to thank the principal of the college for giving me this opportunity to speak on this very important topic. And I hope that you will find this presentation of some use to you. So basically, I will be covering more on copyright and also fair use. But at the same time, we will discuss other issues also with regard to the licensing, what is public domain, etc., etc. So with this, let me just introduce myself. My name is Akhtar Parvez, and I am working as a librarian. Can somebody please keep admitting the participants? Yeah, thank you. So I'm working as a librarian at Maulana Azad National Urdu University, Hyderabad campus. And before joining MANUU, I was working as librarian of Indian Institute of Management, Indore. So basically, the today's presentation, as I said, can is on copyright, as I said. But before that, let me just begin with the definition of intellectual property, which I am sure you all know. Anything which is creation of mind is intellectual property. So, for example, we write books, we write articles, we create designs, we take photographs, we make engineering designs, etc. So all these things come under intellectual property because these are all creations of someone's mind. And the ambit of this definition, which is given by World Intellectual Property Organization, is quite wide, uh, which means that the way I am presenting my talk today is also covered by intellectual property, and this is also my intellectual property. So things like patents, copyright, trademarks, trade secrets, geographical indicators, which actually enable people to earn recognition or financial benefit from what they invent or create, is actually these are part of intellectual property. Now, when I say geographical indicators, which means things like Tata, sorry, Darjeeling tea or Assam tea, etc. These are geographical indicators. And all kinds of intellectual property is protected by some or the other law. Okay. Now, just to give you a brief of patent, which I'm sure yesterday you must have heard someone speaking on this. But the patent is basically an exclusive right which is granted for an invention. Okay, and this the law protects you for about 20 years in India, right? Now, when we talk of trademark says basically some legally reserved symbol. Now, for example, if you see the definition which is given by Merriam-Webster's dictionary, it says a device such as a word pointing distinctly to the origin or ownership of merchandise to which it is applied and legally reserved to the exclusive use of the owner as maker or seller. Now, for example, these are a few things which are before you. I mean, these are few things, which you recognize just by seeing their trademarks, Cadbury, Godrej, Coke, etc. So these are basically trademarks. Trade secrets are something, which are secret to the company and which provide competitive advantage to that company. Now, for example, how McDonald prepares burger, or how KFC, what is the recipe of KFC for preparing chicken, etc. All these are trade secrets. So these trade secrets are also protected by the by some law. Now, as I said, these are protected by law, And these are some of the important laws that we have today in India, starting, with Copyright Act of 1957. Then, we have Patents Act of 1970. Then we have Trademarks Act, Design Act, etc., etc. So these are some of the uh, laws related to the intellectual property. Now the question is, why we need these laws? Okay, can some okay? Why we? The question is why we need these laws. So obviously, because of the fact that we publish books, we invent various things like cars, we produce films, we come with various medicines like COVID vaccine was there. So say, for example, if this protection was not there by law, what will happen? We probably will not be incentivized to invent or write books or produce movies and come out with vaccines. So that is the reason, why we need that there should be some law which should be protected by, which we should get protection for. Now, that the movies which come, they get leaked quite often, and on YouTube, they are very easily available, the pirated copy. Now, this movie, say, for example, the latest movie of Shah Rukh Khan, that is Jawan, that was also pirated after some days, and it was available on YouTube. Similarly, if you see other movies, there was a news which stated that Rais, one of the movies of Shah Rukh Khan, was most pirated Bollywood film of 2017, followed by Hrithik Roshan's Kabil, Akshay Kumar's Jolly LLB 2, etc. Now, what happens that, when such things get pirated, or if someone starts making photocopies of my book which I have just produced or written, then what will happen? Because of these things, there will be loss of revenue. Loss of revenue not just to me but also to the government, because in the process of making a movie or writing books, or because it's a part of a publishing industry, so we lose a lot of money, and in the process a lot of employment is lost. And that is the reason why we need to have such laws. Now, as I said, I'll be focusing more on copyright. So what is copyright? Copyright, again, is a type of intellectual property. But this particular type of intellectual property, which is copyright, this basically protects creative works, number one, but it should be in some protectable expression, okay, which means that it should be in some form or the other, like book, some design, etc., which is not true for patent, because patent can be given to an idea also and can be filed with the registrar. Now, in this copyright, when I say, obviously some amount of creativity has to be there. Okay. And also, it should be unique, which did not exist before. And as you all know, that creativity plays a very important role in the progress of any society. And for any country, it is very important that there is creativity, because if creativity is not there, then perhaps, we will not really be able to move forward in scientific development, etc. And these copyright laws basically, they give authors, artists, performers, producers of music, and other creators protection for their works. And if you want to read more on this, you can go to section 14 of the Indian Copyright Act of 1957 and just read more on this particular aspect. So, as I earlier said, anyone who contributes protectable expression is protected under the law. So that protectable expression is very, very important. So, there was a case in the Delhi High Court, and this was by Humans of Bombay against, people of India. And, they used to actually tell a lot of stories. So they said that, these people of India, they have actually infringe their copyright. But the court was of the view that idea cannot be protected under copyright. Okay, that can be protected only under patent. And then this particular case was dismissed. So if you may say that it is a state created monopoly, okay, but then and that monopoly is bad for any country. But this particular type of monopoly, which is created by a state, is to incentivize people, incentivize creators. Okay, and in my opinion, this protection actually for some number of years. Obviously, this protection is not for forever. So this basically keeps a balance between the rights of creators and of course general public good. Now, things like, books, plays, designs, painting, movies, software, music, etc., sculpture, design, as I said, all are actually covered under copyright. Now, if you see the history in brief, so what we find that, this idea of copyright emerged only towards the middle or end of the 15th century. And what used to happen was, in England, there was a company, there was a government company basically, and the name was Royal Company of Stationers. That was the only company which was allowed to publish, which means, or you can say, allowed to print. Now, every government, everywhere, throughout the world, if you see, they do not want a free press. I mean, I'm not saying that, they do not want press at all, but somehow they want to control these publications. And that was the reason, the King of England, he decided that only one company will be assigned the job of printing and publishing. And if anybody was printing or publishing other than the Royal Company of Stationers, then that person or company was punished, copies were burned, etc., etc. So what happened, in 1610, that the Royal Company of Stationers got into an agreement with the Oxford University Library. And under this agreement, they were supposed to deposit a copy of every publication. Like, in India, we have Delivery of Books Act of 1954. So that was the reason why still you see in University of Oxford, the libraries are named after Mr. Bodley, who was a librarian there, because he was the one who actually got this done, this agreement with the Royal Company of Stationers of having one copy with their library. Now, if you see the history in India, then it was in 1847 this law came, and then 1914 when the British Raj came, and then today we have 1957 Indian Copyright Act. And after 1957, what we see a lot of amendments done subsequently. Like in 1983, one amendment was done, 1984, 92, etc., etc. And 2012 amendment is very, very important. And why these amendments are done? These amendments are done because of the fact that a lot of new things come, and to accommodate those newer things. Now, for example, earlier the electronic documents were not there, but eventually the electronic documents came, and to accommodate electronic documents, the act was amended. And 2012 amendment is very, very important because of the fact that it gives a lot of exceptions, not just to libraries, but also to people who are especially abled, or you can say people who have sight deficiency, etc. And we will discuss this a little later in our slides. So now the question is registering copyright mandatory, or adding the symbol C within circle is mandatory or not? So it is not mandatory, right? Because even if you put just C within circle, it is protected. Even if you do not put C within circle, You must have seen in various books that are published, either against the name of the publisher or against the name of the authors. This C within circle is given, which actually give prima facie evidence of the ownership. Just a second. Can somebody please enter these two people? I think they want to. I am doing it. Okay. 1 second. Okay. So even if you do not enter this C within circle, that your copyright is protected. But it is always better to put this C within circle. And as I said, that registration of this copyright is not actually required. Even if you do not register, your copyright will be protected. So basically, if this C within circle is written against the name of the author or name of the publisher, it helps you to know who has the copyright of that particular work. So if you see the Copyright Act of 1957, so what basically it does? So copyright basically stands for the legal rights which are exclusively given to authors, or you can say creators of intellectual work. Okay, and uh, the copyright also protects the both, that is published work and also unpublished work, but it should be obviously, as I said earlier also, it should be in any tangible medium of expression, like writing, music, art, computer software, film, etc. And because of the fact that India is member of the Berne Convention, US is also member of the Berne Convention, but we joined in 1928 and US joined quite late in 1988. So because there are about more than 150 countries which are member of Berne Convention, the copyright of us, of people living in India, are protected in those countries, and the copyright of people who produce something in those countries is protected in India. And it is because of the fact that we all are members of Berne Convention. So as I said, whether it is published work or unpublished work, both are protected under the Indian Copyright Act of 1957. Now, these are some of the important convention, which you see. If you want, I suggest, if you get time, you please read it, so that you have a fair idea about all these convention. Now, the important thing is the timeline. For what period the copyright is covered? And because we all are in academics, so we must know what kinds of timeline is there for copyright protection. So historically, if you see, copyright was for initially for 28 years. In fact, it was for 14 years. Then it rose to 28 years, then 42 years, then 54 years, and so on and so forth. But now the copyright protection is given for 60 years. And sometimes in 60 years, I will explain you. Sometimes the copyright remains in force for almost 100 years. And how and why it remains in 100 years? Because of the fact that there is a duration. I mean, of course, during the lifetime of the author, the copyright remains in force. Say, for example, there's a person who has written a book. So obviously, during his lifetime, the copyright protection is given to him, and after he dies, then from the death of the author, 60 years. So in the US it is 70 years, but in India it is 60 years, and those 60 years are calendar years. For example, if somebody passes away today, then these 60 years will start counting from 1st January of next year, that is 2025. Now, in case there are more than one author, there are two authors or three authors, these 60 years will start calculating from the death of the last author. Now, what happens in anonymous and pseudonymous works? It is 60 years from the date of publication. And if those who want to read more on this, the Indian Copyright Act is available on the internet in PDF form, and you can just go to chapter 5 and see section 22 to 29, which actually talks in detail about the duration. Now, this particular thing is, is important. Now, important in the sense because it talks about the ownership. Who is the owner, right? So, author says that, look, I have written the article or the book, and I'm the owner of or the copyright holder. But then, employer says that because of the fact that you have written this particular thing during the period of your employment, so copyright remains with the employer. The publisher says that, you as an author have transfer the copyright to me, and now the copyright is with the publisher. The government says, or the state says, though, look, all these things were produced in India, so the ultimately everything is uh, the copyright is with the state. But obviously, we have to make uh, fair use of these copyrighted material. So, if you go to libraries, you make photocopies of articles, you make photocopies of book chapters, etc. And you are able to do it because there is a concept called fair use mechanism, wherein you can use the copyrighted material without any permission. Okay. Now, for example, if I want to explain to you with some examples. Now, there was a document, which our university prepared on academic ethics, and that document was prepared by me along with the other members of institutional academic integrity panel. So, because this was an assignment given to me by my university, obviously I will not hold the copyright. The copyright remained with the MANUU. But things like books, journal articles, etc. These are all treated as individual rights of the creator or the author. So in this case, the authors will have the copyright of that particular work. Now, what happens, when you take some projects from the ministry? So it all depends what kind of agreement you have signed with the ministry or the department or the funding agency. Now, say for example, if the agreement is that the copyright is with the agency, so obviously it will be with them. But if the agreement says it will remain with you, then it is your property in terms of intellectual property. Now, similarly, the author basically is the first owner of the copyright. Now, if there are two authors, then both the authors will be the owner of the copyright. But in case, now, just to tell you this or to explain this to you with an example. Now, say for example, I have written a book with the help of some other person, and his contribution was that he only gave me one picture of that was owned by him, which I used in my book. Now, in case I want to restrict his ownership, then I can always get into an agreement with that author. Now, if I do not have any kind of agreement, then what will happen? Anything, which is generated, like for example, financial revenue. If some revenue is generated, then both the authors will have equal share of that revenue. But in case there is an agreement between me and the other person, then obviously things will be as per the agreement. And the artist of a photograph, and similarly the painter, etc., they are the owners of their works. Whatever photographs are taken by a particular person, the copyright is with him or her. So this particular thing, this is given under section 17 of the Indian Copyright Act of 1957. Now, let us briefly understand what are the rights of creators. Now, here, the right of the creator is to reproduce the copyrighted works, which means that if I have written a book, I can always, go and reproduce it again and again. I can distribute my work. For example, if I have written an article, so I can, distribute copies in my class. I can sell it. I can rent it. I can transfer the ownership to some publisher. So I have a lot of, rights. Similarly, if I have, say, for example, I have written a fiction, so I can always convert that fiction into a movie or a play because I am the owner of that particular work. So I can also, convert a book chapter into journal article. So all these rights, these are given to me under the Indian Copyright Act. If, say, for example, if I'm a painter or if I'm a photographer, so I can always, display these wherever I want. And as the owner of this copyright, I can grant permission or licenses to others. Now, just to give you an example, say, for example, if say I have written a book and I want to distribute these books to various vendors or libraries, etc. So I can give this exclusive right, which means only this right is to that particular publisher, that only he can distribute my book. Now similarly, if I subscribe to a database in my library, then those are non-exclusive licenses which are given to me. Because why these are non-exclusive? Because of the fact that the publisher is giving these licenses to many people. Okay, and these licenses are only to use, and these are non-exclusive licenses. By purchasing a database or by subscribing to a database, I do not become the owner of that particular database. I simply have the right to use it. Okay, and as I said, it is available both to published and unpublished works. Now, let us also, understand what are the major differences between copyright infringement and plagiarism. And the reason why I want to tell you is because of the fact that sometimes, there is some confusion as to how copyright violation or infringement is different from plagiarism. Now, if you talk of copyright infringement, copyright infringement or violation occurs when somebody uses the copyrighted material without permission, right? And in case of plagiarism, if you are not acknowledging if you are not acknowledging the source, that is plagiarism, right? In case of copyright violation or infringement, only affected party actually can lodge a complaint. But in case of plagiarism, anybody can, go to the higher education institution and lodge a complaint. Now, copyright infringement cases or copyright violation in cases are taken up by the courts, whereas the cases of plagiarism are taken by Departmental Academic Integrity Panel or Institutional Academic Integrity Panel as per the UGC regulation of 2018. And I'm very sure that most of you must have read the UGC regulation of 2018. Now, copyright comes under criminal law system, right? And here the punishment could be, compensation or even imprisonment. But in case of extreme plagiarism issues, at the most, a person can be terminated from his job as a professor or a staff, whatever. In case of copyright infringement, a lot is left on court's interpretation. But when it comes to plagiarism, the chances of interpretation are less, or you can say are rare. And why? Because plagiarism cases are always counted in quantitative terms. Like, say, if it is more than 10%, this will be the punishment. If it is more than 20%, then this will be the punishment, etc., etc. But in case of copyright infringement, as I said, a lot depends on how the court views that particular case. Now, in this case, which is before you on your screen, Vasundhara Das actually is a singer who came to fame with a very famous song of Lagan movie. So what she did basically, she went on a TV show and she sang 9 stanzas of Kajrare Kajrare song of a film which was produced by Yashraj Films. So they said, she did not take, she actually did not take permission from us, and hence it is copyright violation or copyright infringement. But the court felt that if we start taking such cases as copyright infringement, then what will happen is that a lot of cases, the court will be flooded with a lot of cases, because there's a possibility in birthday parties, etc., people sing songs, etc., and then anybody will come to the court, and they felt that it is a trivial violation. It was a violation, but the court felt it is a minor violation, and the court dismissed this particular case of Ishraj film. Similarly, this is a very famous case, which is called monkey selfie copyright dispute. Now, in this particular case, what happened, as I said, the owner of the photograph is the person who takes the photograph. So what happened that, between 2011 and 18, a lot of disputes occurred with regard to the copyright status of selfies. Now, selfie of whom? Selfie of this monkey actually took his selfie. And how it took his selfie, because the photographer, whose name was David Slater. So he was a British photographer, and he actually trained the monkey to take photos. He traveled to Indonesia. He made these monkeys his friend, and created certain situations by which he could take selfies. But the one company called, the not company, but it is an NGO, people for the ethical treatment of animals, and also tech dirt. They were publishing all these things on their website or magazines, etc. And in the process, he lost a lot of revenue, the photographer. And the court finally said that monkey is not a legal person. Hence, he cannot have the copyright, because the copyright can be held only by legal persons, and monkey or animals are not legal person. So finally, it was decided by the court that the ownership of that selfie will be with the photographer, that is David Slater. Similarly, if you see this particular case of Sharbat Gulla, which was, if you remember, this was a cover page of National Geographic, and because of this, the photographer, his name was Macquarie, he made a lot of money from this, and not just he. In fact, National Geographic made a lot of money, and when this photograph was taken, she was only 12 years, which means in 12 years, obviously she was not adult, and she was in no position to give permission, and neither the permission was taken from her nor from her family, because since she was a minor, ideally the permission should have been taken from her parents, but it was not done, and they made a lot of money. Then what happened in 2016, an interview was done of the photographer, and then the photographer spoke about this lady. And then, because of this interview, the Pakistani administration came to know that this particular lady is living in Pakistan illegally. Actually, she is an Afghan girl. So, and then, they've identified the place where she was staying, and then she had to stay in jail for 15 days. So, when she was interviewed, she said that, though this cover brought a lot of fame to me, but then finally, she had to suffer also. So, what I am trying to say here is that, the permission was not taken from this lady. But then, the Macquarie felt that maybe, he should help this lady. So now this is the 12-year-old Sharbat Gulla, and now she looks like this. So he went and asked her, what he can do for these people. So she wanted to go for Hajj, and finally the photographer financed it. But imagine, if she had filed the case, then there's a very high probability that she had got some compensation from the photographer. Now, this is a very interesting case. This is another case which, these authors file against artificial intelligence, the OpenAI, which is also called Chat GPT. So these people, said, these two people, that Paul Tremblay and Mona Awad, they said them that this OpenAI actually breached their copyright law. So why? Because and how? Because they were actually training its model on novels without the permission of these authors. Now, why I'm saying this? Because if you go to Chat GPT, so this particular thing, I gave this prompt, that is summarize in detail the first part of the Cabin at the End of the World by Paul Tremblay. So what happened is people said that if you give this prompt in Chat GPT, which is owned by OpenAI, so you get all these summary of this book, which means that the whole book actually was used by OpenAI without their permission, and that is the case that we have in the court now, in the US court. Similarly, these the New York Times, they actually sued this OpenAI and Microsoft for putting their information to train these artificial intelligence applications. So let us see, what happens. The decision has not come, but if in US, the fair use is broad in scope, and there is no purpose specific limitation, right? But in India, it is not that broad. So after we get the judgment of this particular, then we will particular case, we will definitely know how this case of OpenAI is treated in the future. So basically, the copyright is both legal, at the same time it is ethical. So legally, obviously, as academicians, we should bother more of ethical reasons, and equally important is legal reasons. So we should respect our copyright, the copyright of those who have put a lot of effort, in creating some work. Now, let us also. Hello.
पॉलिटेक्निक के उसपे हाँ पुरते वो बोलते सर्टिफिकेशन अच्छा होना उसमें
ये जरा अपना म्यूट कर लीजिए माइक जरा. Okay, so let us now also understand the issues with the copyright related issues with regard to the digital content. Now, before we understand this, or before I tell you the copyright related issue, let me just explain to you briefly what is digital content, which is actually covered under digital rights management. So what are digital rights management? Basically, these are tools that are used to protect the intellectual property and copyrighted materials from misuse or theft. So DRM is basically all about access. For example, you when you subscribe to Netflix, etc., or any other such service, so only it recognizes you. You are an authorized user. You give user ID and password or whatever, and then only you can use it. Similarly, it also tells you. For example, if we subscribe to some ebooks database or journals database, then what can the user do with the content? Now, can he read the full article? Can he download the full article? Or if not, then how many pages can be downloaded? Can this particular copyrighted material be printed or shared or distributed? And then the next thing is the period. Now, when can the user access? Is there any embargo? Now, when I say embargo, I mean that there are a lot of like, for example, if you see the Indian movies, first they are released on theater and then they come on Netflix or other such TV channels. So the intervening period is called embargo, which is also true in case of journal article. Now, sometimes an article is printed in printed copies of journals, but it takes about 6 months or 1 year sometimes to come in the electronic format. So that period, intervening period, is called embargo. And also then, where can such things be used? So because obviously, you cannot use some database which you subscribe here in India in the US, right? And vice versa. And then how long you can use, which means what is the subscription period. So basically, the digital rights management or digital rights are all about access, okay, nothing else. That is the reason why we as librarians, we prefer going for content which does not have any such restriction, which has, or we popularly it is called no DRM content. So this was all about the digital rights management. Now, this is a very important question which I am asking you, and at the same time, I will be explaining to you this particular thing. Now, how do I decide about using any copyrighted material? Okay. Now, before we try to answer this question, let us understand these five things. One is public domain, one is exceptions, the other is licensing, and then permissions, and then fair use. So let us have some understanding of these five things. Five things. So public domain refers to creative works that are not protected under copyright and any other form of IPR laws. The public owns such works, not an individual creator. No permission is needed to use such works which are in the public domain and are not copyrighted. Now, can you say that all open access content which is there on the internet is public domain information? No. Why no? Because there is a possibility that these open access content will also have some copyright licensing associated with it. So uh, the understanding of public domain can be understood by these three things which are listed here. Now, the work falls under the public domain if the copyright term has expired, number one. Number two is the copyright owner puts his or her work in public domain. That's also called actually dedicated work. So if I put something in on the internet and I say, it doesn't have any copyright, so that is public domain information. And then, things which are not copyrightable. So, for example, titles of books, you see the same title having different authors of different books. Similarly, the facts, slogans, or short phrases, these are not copyrightable. So only, the public domain information will be only if these three conditions meet. Okay. Now, let us understand exceptions. So, in the Indian Copyright Act, there is a classroom exception. So, now when I say exception, I mean that these things are permissible. These under the Indian Copyright Act. Now, you can, distribute copyrighted material in your class, provided that university or institution should be not for profit organization, right? Number one. So there is no problem in distributing copyrighted material in your class. But when it comes to online class, then there are a lot of precautions we have to take. First, we should make sure that only a close registered group of students is part of that particular class. And it is the responsibility of the institution which should create a mechanism where the IPR uh, are protected and there is no unauthorized distribution by either students or someone else. Now, which means if you see in our university, so there are a lot of firewalls, etc., kept under our server. So why these are basically just to check that there is no unauthorized person getting into the network of the university. Now, in case of physical classroom, there are a lot of things you can do, but in case of online class, as I said, it is quite restrictive. The things which you can do in a physical class, you cannot do in an online class. So what we should do is basically, you should ensure that they nobody interferes in the DRM technology. And why DRM technology has been put in place? Because of the fact that they do not want that it should be misused, right? So what options we can explore. One is, we can log files, we can do online streaming. We should disable right click. We should use low resolution pictures, and we should ensure that there is no download option in our online classes or digital classes. Now, can you put an article which you distribute in a physical classroom, which is a copyrighted article? Can you put that article in your YouTube video as a PDF? You cannot, because if you put that thing, then it will be considered as distribution, and distribution is not permitted in the Copyright Act. Now, what you also see today is that a lot of newspapers, there are a lot of WhatsApp groups which are there. People send full text of newspapers and some magazines in that group. So, is it copyright infringement? Yes, it is copyright infringement. Okay, so what you should do is, if you are sending it to one person, that's fine. But if you are sending it to the whole group, then there's a problem. Now, there are some exceptions in the Indian Copyright Act which are given to libraries. So, libraries can make 3 copies of any book which is damaged or about to be damaged. But, the library must make sure that that particular book is not available in the market at a reasonable price. Now, what is a reasonable price? Reasonable price can be different for you, it can be different for me. So, if the original cost of the book is 100 rupees, then if I go to the market, and if I'm getting it for 150 rupees, probably I may think that it is reasonable. But you may think that no, it is not reasonable, it is quite high. It is 50% more than the original cost. So in such case, you can make photocopies, but maximum 3. The exception in this, and these are the 2012 exception. These were the amendments of 2012. I'm talking in the Indian Copyright. So also, the amendment allows me to digitize everything which I have in my library, but for only for the purpose of storing, not for distribution. So that is another exception given to us in the Indian Copyright Act. And then, we for physically challenged people, or you can say the specially able people or who have sight deficiency. So what you can do is you can convert text into speech and can give it to such person who cannot, see properly or who has sight deficiency. Now, the third thing is licensing. This is very important, and I think we should understand it well. It means that permission to use any copyrighted material. It is also called terms and conditions, terms of service, or terms of use, etc. And as I said earlier, also unlike print material, online content comes with huge restriction. Okay, so for example, you can sell the second-hand. You can send the printed copy in the second-hand market, but can you sell an electronic book in the second-hand market? You cannot. Why? Because there are a lot of restrictions when you talk of online content. Now, here, say for example, if I want to use this particular picture, okay, in my video or in my presentation, can I just use it? No, I cannot use it. So what I will do is I'll just go to this picture. I will check what this picture is, and it tells me, okay, this is the library of some country, and then I go to the licensing terms, and then I see these are the terms of use. So I read it, and if it allows me, only then I will use it in my presentation. If you go to Google Images and if you want to download pictures, make sure that those images are not copyrightable, or if they are copyrighted, make sure that there is proper license which allows you to use it in your presentation. So what you can do is if you go to these Google Images, if you go to tools, it tells us about the usage rights. So what you can do is you can go to Creative Commons licenses and use what are Creative Commons licenses. Basically, the Creative Commons licenses are those licenses where the licensing policy is easy or liberal, whatever you want to call it. So you can always sort this by Creative Commons licenses and then use it. Similarly, if you go to Flickr website, here you see all Creative Commons pictures, and those pictures can also be used, provided you give uh, you acknowledge this. Similarly, if you want to use a video clip from any video, so always make sure that you go for Creative Commons licenses video, or videos which do not have any license associated with them. Now, what are Creative Commons licenses? Basically, these are easy licenses, you can say. And if you want, you can also prepare anything under these Creative Commons licenses. So, uh, I think somebody's mic is on. Can I just request them to please mute themselves? Yeah, madam, can you please mute your mic? Thank you. So, this is the attribution I was talking about, Creative Commons licenses. So, if any particular thing is by this particular license, then this is CC by, which means, this license lets others distribute, remix, adapt, and build upon your work, even commercially, as long as they credit you for the original creation. So what does it mean? It means that if there is any copyrighted material with this particular license, so I can use it the way I like. The only thing is I have to just give the credit, or I just have to tell people that I've taken it from there, and I can use it for non-commercial purposes also, or commercial purposes also, right? This is by essay. So what does it mean? So if I use anything from this particular license, then I will have to make sure that I also produce my work under same license. That is by essay, share alike. Okay. Now the third is by NC, which means I can use any such licenses works only for non-commercial purpose, not for commercial purposes. So what you can do is you can go to this Creative Commons license website, and there are a lot of options. You can just read it and understand how it works. Also, if you want to create anything if you want to create any work yourself, and if you have any confusion in choosing the license, then you can simply follow this particular thing, and you can start filling this, and then it will guide you. It will tell you which license you should use. Then the also there are things under there are a lot of things for libraries licensing agreement. So I will really not go into the details of this, but what I want to tell you is that all the library databases which are subscribed, please make sure that you follow or you understand what is the licensing agreement the library has signed with the publisher. Accordingly, you can use such copyrighted material. And now the fourth is permission. So obviously, as I said, if you want to use any copyrighted material, you have to take permission. So first is that you have to identify who is the copyright holder. You have to send a formal request, and you have to be very clear about the scope, what kind of permission you need. Say, for example, if there is a picture or painting which you want to use, and the copyright is with someone else, then you have to tell this person that, look, I want to put that image on my cover of the book or inside, so that for example, if you uh, the author or the copyright holder may allow you to use the picture in the book without any charges, but if you say that I want to use it on the cover, then there's a possibility that he or she may charge something from you. So you have to keep this permission safe, because of the fact that sometimes the copyright remains in force for even 100 years or more than 100 years. Now, this is the last thing, the fair use. So, out of those five things which I was tell you, fair use is basically a legal doctrine which allows a person to make limited use of copyrighted work without the permission of the owner, right? Now, we have, to some extent, we have understood these five things, that is public domain, exceptions, licensing, permission, and fair use. Now, again, I come back to the same question, that how do I decide about using any copyrighted material? So, first thing, if I want to use any copyrighted material, first thing I need to check is is the material which I want to use is copyrighted or not. So if it is not copyrighted, then my problem is solved. But say, for example, if it is copyrighted, then I will try to explore the exceptions which are given in the Indian Copyright Act. Now, say, for example, if there is no exception, then I will see, if there is any license which protects the copyrighted material. And if I see that even under any license, I am not able to use it without the permission, then, again, I will see if I can use it under fair use mechanism, which means I can use limited portion of the copyrighted material without the permission. And say, for example, if I find that, okay, I cannot use it under fair use mechanism, then I obviously need to get permission for using that particular material. Now, say if I don't get permission, then I can again try exploring the possibility of using that copyrighted material under fair use mechanism. So these are the 6 things which I thought I must tell you, that this is how you can take a decision with regard to the use of copyrighted material. Now, this copyright uh, thing is quite clear. We all understand it. But the problem is with fair use. What is fair use? So that is the understanding now we will try to have in next 2-3 minutes, and then we will wind up the presentation. So, you know, this I went to the Columbia University website and found that there is a checklist for using copyrighted material under fair use mechanism. So under this checklist, 4 things were given. That is, what is the purpose of use, what is the nature of material being used, amount of use, and impact or effect of use. Now, say, for example, if we start seeing the purpose of use. So if the purpose of use is research, teaching, scholarship, if it is not profit educational institution, if the purpose is if making a comment or criticism or news reporting, then it favors fair use. If it is transformative or productive use, again it favors fair use. So what is transformative or productive use? Transformative or productive use, maybe, say, in my library, what we have done is that we have put all the books details, we have put all the digital content, everything on a particular library page, and everything can be accessed from that particular page. So that is basically transformative or productive use. So that also favors fair use. But so if I want to use it for some commercial purpose, say, if I use it for entertainment, say, for example, if I want to show a movie to my students in a classroom, that is research and research, teaching, or scholarship purpose. But if I want to show that movie in a club to students for entertainment, then it opposes fair use. Okay. Now, the next is nature of material being used. If the nature of material being used, if the material is published work, then it favors fair use. If the information is factual or it is non-fictional based, then it favors fair use. But if it is unpublished work, then I have to be a little careful. If it is creative work like novels, films, plays, etc., then probably I have to be very careful because it opposes fair use. Now, the third is amount of use. If the quantity is small, there is no problem, but if the quantity is large, then it will not favor fair use, rather, it will oppose fair use. And the last is impact of use. So, for example, in a library, if I start making 10 copies of or 5 copies or 6 copies of books, then what will happen? The impact will be that it will have negative impact on the sale of book by the publisher. Okay, and say if the publisher has the copyright, then obviously it will oppose the fair use. So we if we understand these 4 things, I think we will be in a better position to evaluate what is fair use and what is not fair use. When I was talking to you about fair use, I said that a small quantity there is no problem because it is fair use. But if you see the Delhi High Court judgment, which was passed by Justice Enlaw, I think in 2016 or so, so it actually changed the definition of fair use, or you can say the small portion, how it changed. Let me just in 1 minute explain to you about this course. So what happened is Oxford University Press, Cambridge University Press, and some other publisher, they went to the court, and they said that the Rameshwari photocopy service, which was in the University of Delhi, they were making photocopies of their books, and it is the copyright infringement. But the judge said that, or his name was Justice Endlaw. So he said, the India is a poor country. Libraries cannot buy the same number of copies of the students which are admitted in the University of Delhi, and the purpose is, teaching, research, etc. And the judgment was that it allowed the Rameshwari photocopy to carry on the business of photocopying. But then, I personally feel that that was perhaps not the right judgment. And it was also reflected in one of the editorial which was published by the Indian Express, in which it said that ruling in Delhi University copyright case reflects the inability of Indian courts to integrate legal outcomes with robust business models. So this, I think, is quite interesting, and you should read it. So, in my opinion, the judgment ignored the quantity, and fair use mechanism is basically only for a small quantity. So, also I said that every judgment could be different, because the court may interpret it differently. So the best thing would be that we respect the IPR of authors and creators, and we do not get into trouble of copyright infringement, etc. So there are a lot of other things also, which I don't have time, so I will skip. These I suggest that probably you should read these articles, which was of this particular internet archives, and this every I think every student now knows that this is a court battle which is being fought by Sci-Hub and some people in India, and at present, this particular site is banned in India. So with this, I would like to thank you. I'll just skip, and the conclusion is, we should understand the fair use well. We should always read the fine prints which are given in the licenses. We should keep the permissions safe. We should respect intellectual property rights of others, and to the extent possible, we may consider publishing in open access platform, which obviously has liberal licensing policy. So with this, thank you, and thank you, madam, for giving me the opportunity. So I'll just stop sharing, and I will be happy if you have any question. I'll try to answer. Actually, somebody is speaking, but hello. So I
ऑनलाइन बोर्ड से जुड़े शिल्पा कुछ सवाल पूछना चाहते हैं, तो यहाँ पर डिस्कशन के लिए सेशन ओपन किया जाता है।
Hello, I was not able to hear.
सर से सवाल पूछना चाहते हैं, तो उन सवाल को करने के लिए मैं हमारे असिस्टेंट प्रोफेसर मिसेस मैसरा अजीज खान को मदद करती हूँ कि वो आए और सवाल पेश करें।
जी जी बिल्कुल।
अस्सलाम वालेकुम सर। सर एक पार्टिसिपेंट का एक क्वेश्चन है कि अगर किसी किताब का कॉपीराइट किसी फर्म के पास है और उसकी डेथ हो जाती है, तो उसके बाद क्या प्रोसेस रहती है? वो कॉपीराइट किसी और को जा सकता है, मतलब कुछ इस तरह की प्रोसेस हो सकती है।
एक बार सवाल दोबारा से रिपीट कर सकती हैं मैडम? मैडम एक बार सवाल रिपीट कर सकती हैं?
रिपीट
जी सर। सर अगर किसी ऑथर का कॉपीराइट किसी किताब वगैरह पे है, किसी तरह के तहरीर पर उसका कॉपीराइट है और उसकी डेथ हो जाती है, तो उसके बाद वो कॉपीराइट किसी और को मिल सकता है अगर वो उस पर कुछ काम करे उसी
नहीं,
तरह
देखिए
के।
देखिए ऐसा है कि अगर किसी ऑथर की डेथ होती है तो 60 इयर्स तक उसका कॉपीराइट प्रोटेक्शन उनको मिलता ही है। ठीक है, 60 इयर्स के डेथ के बाद तक, तो उसके 60 इयर्स के बाद उस किताब को चाहे ट्रांसलेट करें, चाहे उसका कॉपीराइट खत्म हो जाता है बेसिकली। फिर किसी परमिशन की जरूरत नहीं रह जाती किसी से। तो आप उसको ट्रांसलेट करना चाहें, अक्सर ऐसा होता है कि हम लोग किताब ट्रांसलेट करना चाहते हैं, लेकिन क्या होता है कि कॉपीराइट रेस्ट्रिक्शन की वजह से हम नहीं कर पाते। लेकिन अब जैसे एक एग्जांपल मैं इस पे देना चाहूँगा कि जैसे मौलाना आज़ाद जो अखबार निकाला करते थे, अल हिलाल और अल बलाग, तो अब वो अखबार जो है वो जाहिर है कॉपीराइट से बाहर है, क्योंकि उनकी डेथ को 60 ईयर से ज़्यादा हो चुके हैं। So now we can do anything of that content what we want, because 60 years have already passed. So we obviously will have to wait for at least 60 years, because that is the timeline or period given in the Indian Copyright Act.
एमडी महफूज आलम का था। बहुत बहुत शुक्रिया। तो अब यहाँ पर डिस्कशन सेशन मुकम्मल होता है। अब मैं सर के सेशन पर तासुरात पेश करने के लिए हमारे इदारे की प्रिंसिपल मैडम डॉक्टर पान शहनाज मैडम को बहुत ही अदब व एहतराम के साथ मदऊ करती हूँ कि वो यहाँ आए और इस सेशन पर अपने तासुरात पेश करें। अस्सलाम वालेकुम। डॉक्टर अख्तर परवेज साहब हमारी यूनिवर्सिटी हैदराबाद के लाइब्रेरियन साहब हैं। इनकी हमेशा काविश रही है, कोशिश रही है कि किस तरह से रिसर्च, प्लेगरिज्म, कॉपीराइट इस कंटेंट को बच्चों तक ले जाए। देखा जाए तो सर्व शोभा लाइब्रेरी का है, लेकिन वो हमेशा 4 कदम आगे बढ़कर स्कॉलर्स, फैकल्टी मेंबर्स इनको तहरीक देने के लिए बाकायदा अपने तौर पर भी सेशन का एहतमाम करते हैं। आज के इस सेशन में सर ने डिजिटल कंटेंट क्रिएशन, टेक्नोलॉजी, कॉपीराइट, लाइसेंसिंग एंड राइट मैनेजमेंट की बात की। आपका प्रेजेंटेशन जामे था, कई चीज को वजाहत दरकार थी, लेकिन इतने सिंपल वे में सर ने उस चीज को बताया कि कोई कंफ्यूजन का सवाल ही नहीं। सीधे सवालात, मैं कहती हूँ ना, एक या दो ही मुझे ऑनलाइन भी दिखाई दिए। इंटेलेक्चुअल प्रॉपर्टी राइट और इंटरनेट, इसमें कहें तो हम अभी सर्द जंग चल रही है। आज कॉपीराइट के शोबे ने इंटरनेट को कोर्ट तक ले गए और उस पर बाकायदा बात करने की बहुत जरूरत है। अगर एक छोटा सा भी एड, छोटी सी भी न्यूज, उसको कॉपी करके कहीं सर्कुलेट करते हैं, सिंपल वीडियो भी कह दे तो आपने बनाया है, कोई उसको यूज करता है और उसे अपना नाम देता है, तो वो भी एक बाकायदा इलीगल काम है। तो सर का जो था इम्पोर्टेंट ऑफ आईपीआर लॉज, इस पर बात करना हमें इस बात की आगाही देता है कि किस तरह किस चीज को एक न्याय, एक अदब के दायरे में इस्तेमाल करना है, और वो भी आईपीआर रूल्स के तहत। कॉपीराइट पे सर ने तफसील पे बात की, उसकी हिस्ट्री पर एक सरसरी नजर भी दौड़ाई की। इंडिया में कब इसका सिलसिला शुरू हुआ, ब्रिटिश ईस्ट इंडिया कंपनी जब स्टैब्लिश हुई थी तभी से कॉपीराइट को राइज किया गया है। और आपकी बात क्रिएटर्स राइट, कॉपीराइट इन्फ्रिंजमेंट,
इन तमाम शोबों को छूते हुए एक कंप्लीट दायरा पेश करती हैं कि आईपीआर क्या है। हम आप यानी स्टूडेंट्स कह दो, फैकल्टी कह दो, एग्जीक्यूटिव्स कह दो, एक जुगाड़ू भी कह दो जो शायद एजुकेटेड नहीं है लेकिन उसमें तकनीकी जहन है, उसमें वो क्रिएटिविटी है कि उसने अपनी तकनीक को इस तरह से बनाया है जो बिल्कुल क्या है, बिल्कुल यूनिक है। तो उसको किस तरह से मार्केट में लाकर पेटेंट या उसका कॉपीराइट किस तरह से हासिल किया जा सकता है। तो बहुत बहुत शुक्रिया अख्तर साहब, हम आपको यूं तकलीफ देते रहेंगे और इंशाल्लाह आपका साथ रहेगा। तो एक इनेकाद करने वाले हैं वर्कशॉप एक दिन का, जिसमें आपको लाइब्रेरी के ताल्लुक से प्लेगैरिज्म पर बात करनी है, बाकायदा बताना है कि किस तरह से सॉफ्टवेयर के जरिए हम हमारे कंटेंट को जान सके कि ये प्लेगैरिज्म से फ्री है। बहुत बहुत शुक्रिया। ओवर टू हाजरा मैडम।
Thank you, madam. It was a great pleasure, and it will be an honor to be associated
तो
with.
हमारे 2 रोजा वर्कशॉप के दूसरे दिन का पहला सेशन यहाँ पर मुकम्मल होता है। अब हम दूसरे सेशन की जानिब बढ़ते हैं जो कि डॉक्टर मिर्जा शाहिद बेग सर देंगे और उनका अनुवाद रहेगा पेटेंट एप्लीकेशन प्रोसेस फ्रॉम फाइलिंग टू ग्रांट ऑफ पेटेंट्स। सर का तारुफ पेश करने के लिए मैं हमारे इदारे की असिस्टेंट प्रोफेसर डॉक्टर मिसेस सिद्दीकी उस्मा तहसीन खान को मदऊ करती हूँ कि वो यहाँ आए और सर का तारुफ पेश करें। Esteemed guests, participants, and dear students, Assalamu alaikum and a very good morning to all of you. It is my pleasure to introduce and welcome the resource person for this session, Dr. Mirza Shahid Beg sir, who will be enlightening us on the topic patent application process from filing to grant of patent. Dr. Mirza Shahid Beg is an associate professor in Department of Pharmaceutical Chemistry at YP Chavan College of Pharmacy, Aurangabad. He has an academic experience of 18 years, specializing in medicinal chemistry, analytical chemistry, and stability studies of drugs. His expertise has earned him national as well as international recognition. He has to his credit 7 patents, including the Australian Innovation Patent. He has contributed chapters and published books of repute. He has published nearly 51 research papers in national and international journals. He is a research guide with 6 research scholars under his guidance. He received many accolades in the form of awards. The few of them I could mention here are the Best Teacher Award, Best Research Paper Award, Dr. P.D. Sethi Research Paper Annual Award, and Ratan Tata Merit Scholarship. So I would request Sir to start his presentation. Thank you, sir. And I would also like to welcome Professor Mohammad Salih Khan, who has joined us online for the reflective session. He's Principal MANUU Youtube. Thank you, sir. आगे पीपीटी बढ़ाते भी जाओ।
नेक्स्ट
एक एक्स्ट्रा ना कर दूं क्या? एक्स्ट्रा रखना।
Okay, thank you very much, madam, for the nice introduction. And I'm very thankful to the one another National Urdu University for keeping this a very important topic, which is a requirement of today. As we are going through the startup process, the government is promoting, Indian government is promoting the startup process. It is promoting the business nowadays, and for that, this intellectual property right topic is a very important topic. As the students are also there, teachers are also there, researchers are also joined all over India, online mode and offline mode also. Okay, many students have come from the various sectors of India. I've just talked to the students also. So, gaining an opportunity. This is what the platform, a very nice platform, which is kept by the College of Teachers Aurangabad, organizing here. So, meaning is to say that the students should take the advantage of this, and they should be planning now. They should be planning for the meetings, for copyrights, for trademarks, because this is the awareness, which is what you are getting, and you should be including in your professional career. Various advantages are there, academic advantages are there, professional advantages are there. Overall, you can say financial advantages are also there. If you understand this, you will avail the benefits of this. So, today's conference is going on. One day is already finished up with a very knowledgeable topics yesterday, and this is the second day. Today we are having again more knowledge regarding this like of the intellectual property rights, patents, and design. I am very thankful to again MANUU and the College of Teachers for giving me an opportunity to talk on my topic of discussion today is patent application process from filing to grant. This is what we have to understand, that what do you mean by filing and what do you mean by grant, and what the journey is going on through this phase, that we have to understand. No doubt, various things are there inside it. We will show you the things that how you can overcome the various difficulties and all that. And main focus as we are learning trademarks, as we are learning copyright. Okay, before me, the speaker, deputy speaker, who has speaker on the copyright. Okay, my topic is on patents. Okay, we have to understand what is patent. Okay, right? from yesterday itself you are hearing about the patents and all that. So again, we will have the brush up, we will have the refreshment of regarding the patents, and then we will have the filing process. How you can file the patent, okay? And what processes is that. And one more important point I have taken in my presentation is the case study. Myself has published the patent, granted the patent, national, international, which has been granted, and we are availing the profits of that also. With regard to my academic career, also I have taken the advantage of that, etc. etc. So, case study, like case study, that how the design patent we have granted, how it look like, what is the process of publication of the patent, where you go through, how much money you require for the patent, because patent is a legal document. Main important. You publish the paper, you present the paper in any conference, it's okay, plagiarism and all that is there. But patent is a legal certificate provided by Government of India. And any patent infringement, if occur, violation if occur, there are penalties also. This all things you should know about the patent. Okay, so the pros is also there, the cons are also there. That also we will discuss in this topic. So as Madam has already introduced myself, is Dr. Mirza Shahid Beg. I am associate professor again, IMC MANUU College, this college itself, IMC MANUU College of Pharmacy. And we can proceed now with our topic. Yes. So again, just as said, that just we will brush up all the 5 to 6 slides. Then we will start with our patent application process. Intellectual property right, as this has been said, it's a creation of mind. What you think new, it is beneficial for the people, humanity. Okay, so that is the creation. For example, Newton, everybody knows in the world, irrespective of the education, science, arts, commerce, Newton's law we follow in the science. The apple fall on the head. Okay, so you think why it falls down? This is the thinking. ऊपर क्यों नहीं गया? स्पेस में क्यों नहीं चला गया? उसके सर पे क्यों गिरा? ऊपर से नीचे क्यों गिरा? ऊपर जाना चाहिए था कूद के. He think creative. What is the reason? Then he gravity and all that is what. So this is the creativity of the mind. Everybody is having the creativity in the mind. Okay, with respect to various things. Somebody makes songs, somebody makes music, somebody makes devices, somebody makes many things. Okay. In the olden days, telephone is there. We have the handle. We have nowadays we are having mobiles. Any new gadgets, new watches comes, it is on the space. Yesterday only I am talking about the expert of the ChatGPT, AI, artificial intelligence. See, we have to flow with the world, current, future. Okay, we are learning the fact theories and all that. That's okay. We have the knowledge. That is what important to make a base. But what next? Today's generation, new generation is thinking of the next. What is next? Okay, we are working on the cloud. Okay, so all these things you should be well aware and you should be in touch with what is happening nowadays. Okay, many new things are coming. So there is a creativity, the idea, intellectual. That is what the name indicates. Intellectual property. The person think, other person doesn't think that. You think that. That is your property, and it has to be protected. Okay. Otherwise, you make the new concept, other take it and they take the benefit from right from yesterday itself. You are learning this. Okay, so without going in the detail of the intellectual property, we are having the parts of the intellectual property rights, like patent comes under that. Copyright comes under that. Trademarks, design, database, trade resets, all these things comes in the, and all are different. That is why we make the different boxes. Patent is different, copyright is different, trademark is different. If we have the comparison, next slide. Very little we will discuss about the legal three things which is in the market. That is trademark, patent, and copyright. What is the difference between these words? It's very easy. Trademark, if you just say protection of the unique name, slogan, logo, any logo. I have here the logo of MANUU. It is unique. You can copyright it. With trademark, you can have the logo. Okay. McDonald's. Many people go for in the holidays for the McDonald's. When they go to the normal house of the Jana, or if you see one person is sitting on the sofa. That is a clown, or you can say a person. Demo is there. But when you go there, you will see the big yellow, and that is a trademark logo for the McDonald's. No one can copy that. That is a trademark. Any logo, any slogan, any unique name, okay, distinct from the other. And on the trademark, it is written I. Various lines on the product. You go to the shopping malls, you go to the you can say for purchasing also, you see the product. And then it is written PNRR. Okay, so it is trademark. This is the symbol which is used to designate that trademark. Okay, these are the legal aspects. No one can take that things, because nowadays if you see many duplications are occurring in the market. Even if you buy the chips, you can say, and that also various companies are. Local companies are also making the same, so that their brand will sell. People will think that this is the company we will take like this thing. Okay, so to protect that, trademarks. Okay, Trademarks Act 1999. See all these legal aspects, legal Indian government have the acts for this. Okay, that is what we have started with. If any violation is there, punishment is there for. Penalties are there with imprisonment to fine. You have to pay. If you copy that, if you do the infringement, if you do the violation with the original, because people do anything for selling their products, for making the benefit of that things, you can say, in the market. So this is what the acts are made, and you have to follow that acts. And if violation occurs, court cases. We have to go in the court and we have to fight for the things. And if you find guilty, many examples have been taken. Okay, from yesterday to today also. You have to fight for the court case. And if you find guilty, you have to you may be having the imprisonment, or you have to pay the fine for that things. So right. Valid for 10 years. See, everything is having some expiry date. Even I'm from the pharmaceutical field. Drugs, we take the drugs. Okay, we make the drugs. So we have the expiry date for it: 2 years, 5 years, 3 years, 6 months, etc. After that, we should not use the expiry date drugs, because they get degraded or either they become toxic to the body. Okay, so everything is having the expiry date. So also this type of the things are also having the expiry date. Okay, till that time you should be having your benefit. For trademark, if you see benefit for 10 years, then can be renewed every 10 years perpetually. If the owner wants, if the inventor wants, he can have this one. Next is copyright. Before going for the patent, because patent is our discussion today, we are finding the difference. What is trademark? Now you can understand, I think so. What do you mean by the trademark? Okay, copyright. Just now, the section has been concluded for the copyright. Protection of original creativity expression like literary, artistic, dramatic work, etc. Okay, many things comes under this. Okay, just for example, some songs are there. Okay, you can have the copyright of that song. Some musical tune, धुन जिसको बोलते हैं, ऐसे ही जो धुन है, so this is copyright. We have the copyright for that. No one can copy that. Okay, so this type of the matters come under the copyright, and it is having the symbol S C and E copyright symbol. Many products you might have seen it is copyright. When you search in the Google also for the research papers for the various elements, it is written copyright. Don't copy this. Many images below it is written copyright. You should not copy and use for the benefit of yours. Like I said, we follow the Copyright Act 1957. Again, the law is there for this. Okay, valid for lifetime of the author plus 60 years after his or her death. जब तक कि वो इंसान जिसने वो सॉन्ग बनाया है या धुन बनाया है या जो भी है, ये उसके लाइफ टाइम तक के वो उसका होता है, वो मर भी गया. After the death also 60 years is what happened. उसके बाद में किसी ने अपने इसमें ले लिया है तो that is not having under the law. So this is how this is a section of copyright. Now coming on to the our main focus of patents. Patents, protection of invention. So very important word, invention. What is new? No one has projected in the world up till now, and you are giving the new one. Okay, COVID-19, if we talk about, because we are from the medical field, no drug is there because of the mutation of the virus. Okay, if some drug which is made, which will kill that virus totally, completely, okay, that will be the invention. In the COVID-19, all are looking after the pharmaceutical companies to build the new drugs. So, means to say that any invention, new invention, okay, so that we have the patent. Okay. A novel, original, and has industrial utility, and you can apply for the benefit of the human beings, and you can have in the industrial process, you produce in a large amount, and like I say, this is the patent. Okay, everything is not patented. That also we will see what are patented and what are not patented. Okay, so no mark or symbol with implementation of the patent. इसको कोई symbol नहीं है. जैसे हमने trademark को देखा है, जैसे copyright को देखा है, वैसे patent का कोई symbol नहीं. This is what the difference. Small in a very simple way. We can have trademark, patent, and copyright. What it is. Patent Act 1970. Again, this is by the jurisdiction, by the law. You can say we have to follow Patent Act 1970. Remember this, 1970. All specifications are given under this. All penalties, all violations, all benefits, all forms, how the patent is granted, etc. In that, many amendments are there. We will see that also. Valid for 20 years starting from the day of the application is first made. Date is very important. When you file today, 10th March 2024, this will be the date which is considered for all the regulations, forms, for all the process, and all the means at the end, this date to last 20 years. So date is very important, and 20 years you can remember that you can enjoy the patent. The drug companies, what they do, they file the patent for their original drug and they enjoy the benefits of that particular drug. Suppose XYZ company made dash drug. Okay, we file the patent, 20 years we get the benefit and we make the no other inventor is there, no competition is there. Suppose the drug is made for 5 rupees, it sells to 20 rupees in the market. You enjoy the benefits for 20 years. Okay, so this is the patent. Again, the invention, we start now with the patent process. Okay, last slide was just to have the difference, because that makes the difference very clear that what is trademark, what is copyright, and what is patent. Okay, so invention, as we have discussed, the new things which are developing. Okay, every mind is created. Your thinking is what you are putting into the mind, and many people they are enjoying that creativity. Okay, many people they are earning from this creativity, and that is the purpose of the painting, that it should be benefit to the others. In return, we will get the royalties for this particular things. So that is the invention, and it is mentioned in the laws 1970. If you take under section 211, it is a definition which is given new invention. Okay, new thing. It should not be any other person who has already proposed that. It should be totally new, and it should be beneficial also. ऐसे नहीं है कि नया है और उसमें कुछ भी नहीं है और उल्टा harmful हो रहा है पब्लिक को, तो वो पेटेंट नहीं होता है. It should be beneficial. उसके साथ लगा हुआ है नया और उसके साथ beneficial. Like for example, for understanding, like education teachers are also there, and we write on the chalk and board for the study. In the olden time, I have also used chalk and board studies. Nowadays, we are using the digitalized models which are available, like the PPTs and all that, Zoom and YouTube Live, etc., etc. So in the olden days, when we or I writing on the board and we rub, it is all dust. So it is breathing affected, body affected, it is catching carbonate. Sure. So nowadays the things have been changed. Just less chalks have been available, which is very beneficial in the new form, in the new way. It is what it is health conscious and like this. So many new creations have been made for this inventions. So, now, what is patent? Just we have discussed about the patent, that the inventions are patented, but actually, what is patent? A patent is a statutory right of an invention granted for a limited period of time to the patentee. Those who apply for patent, it is called as patentee. By the government in exchange of full disclosure of invention for excluding others from making, using, selling, importing the patent product or process for producing the product for those purpose without his consent. So actually, it's a protection right. Okay, your invention get protected. No one can copy it. No one can use it without your consent. If you give the consent, that is also there. Okay, so then we can make the benefit. So this is the patent. Okay, next. Here in one slide we can have the summary of the patent. That legal certificate that gives you the right to protect your invention. Legal certificate by the government. It is given to protect your things. No one can change. No one can copy. If he copy, you file a court case against him, and you have the patent infringement, royalty and all that. Okay, so that is how more concerned to know the patent, how it is filed. It should not be duplication. Many things are there. If you do all these things, it will be very beneficial for you for your career. Patent 20 years, as we have discussed, is having that time limit of term. So you can say Step by step, we are going towards understanding that patent format. It's a contract with the government. You give the public an invention that has never seen before. इस तरह की चीज जो है पहले आपने नहीं देखी है. The government gives you a limited monopoly the patent. देखो कुछ दे रहे आप लोगों को तो आपको भी कुछ मिलना चाहिए उसके लिए. ठीक है. तो what you get a monopoly, a certificate, your copyright. ठीक. तो क्या होगा? सब लोग जो है हाँ अच्छे इंसान होते हैं वो सबके लिए ओपन कर देते हैं, सबके लिए अवेलेबल होता है. कुछ लोग बैठे रहते हैं कि इसने क्या बनाया है, we will produce that and we will take the benefit. अरे वो जो इंसान है उसको बेनिफिट नहीं मिल रहा है और दूसरे उससे
रजिस्ट्री करा.
जब भी हम घर लेते हैं तो उसको हमारे
अपने नाम
पहले नाम पे करना पड़ता है ना, या नहीं करेंगे आप? वैसे नहीं या कोई भी आओ कोई भी रहो वो बोलेगा मैं रहता हूँ आज आप जाओ. To understand this fitting, okay, you have the copyright. You do the registry, you do the PR card, you legalize document that this is mine. I am the owner of this house. I am having the legal, क्या proof है इसका? Legal document. ये registry है मेरे नाम पे, ये PR card है मेरे नाम पे, आप ये ले नहीं सकते. Okay, so like the same thing the patent is there. You develop some new things, devices, many things are there. As in the startup, it is not started. You can say now. Many patents yesterday only it is 70,000, 1 lakh, like this where the patents are given by the government. Why is increasing the numbers? Due to startup. आजकल startup बहुत चल रहा है. एक मेरे पास में अभी आया है पिछले महीने में स्कॉलरशिप का स्टार्टअप स्टार्ट किए हैं कि कॉलेजेस को प्रॉब्लम आता है, स्टूडेंट्स को प्रॉब्लम आता है स्कॉलरशिप फॉर्म्स भरने के लिए. We have started a new startup there. We have certified and organized. So means to say that in every field the people are going for a startup. आप लोग भी सोचो startup के लिए. You can also have the startup, new startup. And for that, if you are having a very new creativity in mind, okay, you first patent it. ये बताना चाह रहे हैं students के इसमें. You take the advantage of patent. You do the patent and you avail the benefits of that. Okay, उसके अंदर और सारे benefits कैसे आते हैं आगे. So here are the benefits. Okay, हम पेटेंट करेंगे तो हमको क्या मिलेगा? Protecting the invention. First thing, पहला चीज हमारा जो इन्वेंशन है हमारा खुद का है उसको हमने पेटेंट करना. ठीक है, we protect it. Next is donating a patent. You can donate also the patent to anyone by the legal aspects. You can say and you can earn from that. Next is patent infringement. Violation. किसी ने कॉपी करी आपका पेटेंट, ठीक है, आप उस पे केस डाल के रॉयल्टी ले सकते हो उससे. इतना भी आपको रॉयल्टी लेना है. It depends upon by the court, you can say. So this is how you can earn from the infringement also. License the patent. If you have any innovative idea, you patent it. Okay, you can have license or collaboration with the industries. Okay, if any industry is interested in your patent, you can have the royalty for that. Suppose for to understand this, मैंने एक ड्रग बनाया कैंसर के लिए एक ड्रग बनाया, ठीक है, एंटी कैंसर पेटेंट्स भी है हमारे. अब वो ट्रक जो है एकदम नॉर्मल है, दुनिया में किसी काम नहीं किया, उसके ऊपर न्यू एनालॉग है। और एक इंडस्ट्री हमको अप्रोच हुआ कि हमको आपका ये पेटेंट चाहिए, तो हम बोलते हैं इसको कि we will license, okay, we can have in the collaboration. So 20%, 30%, how much you will give for the sale of the product, okay? So in this way you can earn. और industry जो है बड़े लेवल पे होता है, okay, millions and trillions, billion dollars companies are there, and product is sold wide in the pharmaceutical field. So they give you the royalty for it. Like the books published by the education department, okay, any new book you sell in the market, okay, for every sale of the book the publisher give you the royalty in your bank account, it comes. Like this way when you select, we can earn on the patent, offering the patent for sale. आपको बेच देना है आपका patent, कोई लेने के लिए तैयार है, so you can have a huge amount for that, whatever you want, and you can sell up that patent. Almost all that you have to file that in as a like this is legal aspect, and you will enjoy the things from that, and you get the royalty for that. Okay, so this is the benefits of patent. So important is the patent. So we are understanding what is there for the patent. Okay, next. Objectives of patent. Discussed into this slide. This is a very important point, that is the protection. To promote the creativity of the new creators, okay? The people are having the ideas, etc. So they promote the new creators that this is how you can have the patent form. To accelerate the technology and industrial development of the country through patenting. Okay, yesterday only we had discussed that in the US, so many patents are there. So what they are doing in the new creativity, they are developing, they are having the new technologies and all that. And it has been started in India also. Now we are also doing in the technological field. So this is how the importance of the patent, that is the objective to make or accelerate the technology. To provide the exclusive right to invention and offer the protection against unauthorized use of the invention by the third parties. Just now we have seen. Understanding the meaning of specification, okay, all the specification related to that invention, you will see. To encourage invention by promoting their protection and utilization. Okay, so this is the objectives that पेटेंट किए तो क्या होगा या उसके क्या मकसद है पेटेंट. Patentable invention. As we have stated just now that everything is not patented. Okay, हर चीज पेटेंट नहीं होती है. तो पेटेंट क्या होता है? That is patentable invention. The following are the basic patentability criteria. ये फॉलो करना है हमको पेटेंट करने के लिए. What is the first? Novelty. नया चीज. बार बार कह रहे हैं नया, जो दुनिया में नहीं है. Okay, so that the concept, new things. देखो हर एक चीज, हर एक प्रोसेस में कुछ ना कुछ खामी है, और उसको दूर करने के लिए आप कुछ बना रहे हो अच्छा, जिससे कि वो चीज दूर हो जाए, और अभी तक कि वो हुआ नहीं है. That is the novelty, new in the world. Okay, that novelty first comes. Inventive state and non-obviousness. Non-obviousness बोले तो आम नहीं, खास है. Non-obvious. Obvious बोले तो आम, सबको मालूम है ये है, ये है, ये है. कुछ खास, कुछ तो भी नहीं है. इंडस्ट्रियल एप्लीकेबिलिटी, ये बड़े लेवल पे जो है इंसानियत को फायदा पहुंचाने के लिए, ह्यूमैनिटी, फॉर द बेनिफिट्स ऑफ द ह्यूमैनिटी, इट शुड बी अवेलेबल टू ऑल in the world, you can say. So that is the industrial applicability, and it is now fall under the section 3 and 4 of that. Section 3 and 4 is what is not patented. That the next slide we will see. This is called as patent, and this is those things which are patentable. ये criteria है, 3-4 criteria दिमाग में रख सकते. Yes, next. पेटेंट कैन बी ग्रांटेड फॉर। अभी 3-4 चीजें आपके सामने रखे, आपको समझ में आ जाए कि क्या क्या पेटेंट हो सकता है मोटे मोटे चीजों के अंदर। प्रोडक्ट, डिवाइस और सिस्टम। प्रोडक्ट, ड्रग प्रोडक्ट है, पैरासिटामोल है, एस्पिरिन, पुरानी है, कोई नया ड्रग आपने बनाया है किसी बीमारी के लिए, ठीक है, इट इज पेटेंटेबल। डिवाइसेस, मेनी डिवाइसेस आर देयर, मोबाइल इज आल्सो अ डिवाइस, ठीक। तो अस्थमा के लिए जो पंप लेते हैं वो भी एक डिवाइस। पहले लोग भाप लेते थे, अस्थमा आया, ये आया, सांस की प्रॉब्लम है, पहले के जमाने में भाप लिया जाता था, गर्म करते थे पानी उसमें। जस्ट small example. Nowadays we are having the devices, we are having the pumps, actuated pumps which deliver the drug to the respiratory tract. रास्ते में क्या अटैक किया है जो भी सॉल्व होता है, bronchodilation को यूज करता है, salivary etc. So this is what devices, systems which are following for the process. Okay. Next is process, method and uses. Process, ठीक है। अब पहले के जमाने में काढ़ा बनाया जाता था गर्म करके पत्तों को डाल के जो। Now we are having the extraction procedures. This is a very hot topic of extraction. लोग इससे कमा रहे हैं। अदरक जो होती है, अदरक का ऑयल जो होता है वो कैसे निकालना? अदरक बहुत हार्ड होती है, ठीक है, तो उसको क्रश करना, कैसे करना, कौन सी मशीन लगाना है, क्या करना है। और ऑयल बहुत दिखता है इसका मार्केट में, आप इंडस्ट्री को बेचोगे ऑयल, ये 1 किलो अदरक में से थोड़ा सा ऑयल निकलता है। तो दैट प्रोसेस इफ यू डू, आपके दिमाग में कुछ है तो बोलिए, आप अपनी पेटेंट करेंगे इसको, ठीक है। ये कमर्शियल रिक्वायरमेंट है। आप मार्केट में क्या चाहिए वो देखो, बहुत सारी चीजें हैं। ये तो एक दरख्त का तो छोटा सा एग्जांपल आपके सामने रखा, बहुत सारे एग्जांपल्स है जिससे लोग फायदा। दिस इज व्हाट क्रिएटिविटी, दिस इज व्हाट पीपल्स आर अर्निंग थ्रू देयर माइंड्स। दिमाग से जो कमाया जाता है ना, वो ये चीज है। और उसके लिए हमको क्या प्रोसेस फॉलो करना पड़ता है लीगल, दैट वी आर डिस्कसिंग। ओके, कंपोजिशन प्रोसेस, कंपोजिशन समझो केमिकल मेथड है, फ्रॉम द साइंस फील्ड है तो मैं केमिकल के बारे में बात करूं। तो रिएक्शन, ठीक है, एक रिएक्शन, एक ड्रग बनाया जा रहा है 4 से 5 स्टेप में, क्योंकि एक डाला सब उसके अंदर ड्रग बन गया ऐसा नहीं होता है, ठीक है। आपने एक स्टेप से एक प्रोडक्ट बनाया, इंटरमीडिएट बनाया, फिर उससे दूसरा इंटरमीडिएट बनाया, फिर लास्ट में प्रोडक्ट बनाया। अभी 4 फेज है आपके, उसमें टाइम, chemicals, method. I developed one method which is one pot reactions is supposed to be, I put all the things and produce a drug. ये novelty है, 4 मेथड फॉलो करने से अच्छा एक ही मेथड से आप here, but it should be new and having the good yield, and this is called as process patent. This is composition in the chemistry. और जो चीज नहीं हो सकती है, जैसे कि but not for just an idea like a time machine. टाइम मशीन पे लोग काम कर रहे हैं, न्यू कॉन्सेप्ट। वो मूवीज में बताता है कि यहाँ पे टाइम मशीन में बैठा और 1977 में आया कि गांधी जी के पास में, मतलब और आगे 1920 में गांधी जी के पास में बैठे। तो this all things ये पॉसिबल नहीं है अभी, इट इज नॉट practical. Inventions which are not patented, ये भी मालूम होना चाहिए। अब patented क्या होती है चीजें वो मालूम है, क्या नहीं हो सकती है। Frivolous invention मतलब बेतुका invention बोलिए तो चलिए, जिससे कोई फायदा ही नहीं है, बस ऐसे सोचा ऐसा होना चाहिए, तो ऐसा नहीं होगा। उसके लिए जो है कुछ लीगल मींस क्या बोलेंगे इसको, जस्टिफाइबल रीजन होना चाहिए कि ये सही में ये फायदेमंद है। तो फ्रिवोलस मींस ऐसी any invention that is against the public order and is capable of harming the environment, any religion or any group of individuals or that the public at large, जो भी नुकसान पहुंचाने वाली चीज है वो पेटेंट नहीं हो सकती। ये बहुत सारे एग्जांपल्स है, कुछ भी बना दिए जो कि हार्मफुल है इंसान के लिए, वो पेटेंट नहीं करते। दिस इज अंडर द गवर्नमेंट रूल व्हिच इज नॉट पेटेंटेड। Mere scientific discovery or abstract theory and physical applicability theories भी आप नहीं फॉरवर्ड कर सकते पेटेंट में। A discovery of any living or non-living object भी नहीं कर सकते हो। Mere discovery of known substance not including the efficacy of that substance, ये बहुत अच्छा है। एक इसमें केस स्टडी भी आया था एक फार्मा इंडस्ट्री का। फार्मा इंडस्ट्री का पेटेंट एक्सपायर होने वाला है, 20 इयर्स कंप्लीट हो गए, उसने एंजॉय कर लिया पूरे अमाउंट, ये वो बहुत कमा लिया उसने। अब वो जाने नहीं देना चाहता था वो ड्रग को, तो उसने क्या किया है, कुछ तो भी मॉडिफिकेशन, अब ये ड्रग है उसके ऊपर एक ग्रुप लगा दिया, ये नया है, मगर उसकी जो एक्टिविटी है, जो इफेक्ट मिल रहा है उससे, तो पेटेंट का ऑफिस ने क्या बोला, गवर्नमेंट ने क्या बोले, इसमें क्या नया है, तुमने ये लगा के हमारा इफेक्ट वही मिल रहा है, तो ये नहीं। इंटरेस्टिंग, लोग कुछ भी करते हैं अपना पेटेंट बचाने के लिए, क्योंकि उससे हमको फायदा हो रहा है ना, फाइनेंशियल फायदा हो रहा है, तो वो ऐसा नहीं कर सकते क्योंकि कुछ फायदा ही नहीं है ना उससे, कुछ भी नहीं है, वही सेम इफेक्ट मिल रहा है, तो क्या नया है इसके अंदर, दैट इज हाउ दैट टाइप substance created merely by mixing of the two existing substance, मतलब ये plant related। here we are having a reconstruction of the existing device, okay, device बनाया है किसी और ने, और आप इसको थोड़ा सा मॉडिफाई कर रहे हैं, मगर इफेक्ट वही काम वही कर रहा है, it is not next slide connectivity।
क्वालिटी ले लो।
Next is method for agriculture and horticulture. It is not patented for the agricultural reason for farming. If it is there, it is not patented. Any process for treatment of human or animals, okay, it is not patented. Biological है, ठीक है, it's a process of treatment, तो वो patent नहीं होता है। What defined as under the copyright, it is not patented, वो copyright होगा, copyrights patent नहीं कर सकते। Method of doing any mental work or playing a game, वो भी आजकल तो बहुत चल रहा है, गेमिंग सिस्टम हो रहा है, ठीक है, it's not patented। Presentation of information, it is not patented। Topography of integrated circuits, जो engineering में होता है। An invention made purely from traditional known components, ठीक है, अमीन का फायदा ऐसा है कि गर्म करके खाओ तो हमारे एंटीबैक्टीरियल एक्शन वगैरह लोग आते हैं नीम के पानी से, तो वो पेटेंट नहीं कर सकते। इन्वेंशन रिलेटेड टू एटॉमिक एनर्जी, ये बहुत ही इंपॉर्टेंट है, इसको बहुत हाईलाइट किया है गवर्नमेंट के इसमें। एटॉमिक एनर्जी या डिफेंस के अंदर कोई भी सिस्टम का पेटेंट नहीं किया जाता, ठीक है, सो दिस आर द थिंग्स व्हिच आर नॉट पेटेंटेड। तो अभी हमको क्लियर हो गया कि क्या पेटेंट कर सकते हैं हम और क्या नहीं कर सकते, ठीक है। नेक्स्ट वीडियो, types of patenting application, going for the patent application now। For first we should know that what are patenting applications, कितनी तरीके की आप patent application कर सकते हो, ठीक है। ordinary patent application, that is utility patent, normal जो patent होते हैं इंडियन गवर्नमेंट को, that is ordinary patent। divisional applications, we can file the divisional application। समझो एक पेटेंट है आपका, उसमें तीन चार नई चीजें है, तो आप हर एक को एक एक पेटेंट करके डिवाइड करके, मींस टू डिवाइड, और वो तीन पेटेंट आप उसके लिए फाइल कर सकते हैं। सो दिस इज डिविजनल एप्लीकेशन। नेक्स्ट इज पीसीटी, इंटरनेशनल एप्लीकेशन। पीसीटी मींस पेटेंट कॉर्पोरेशन ट्रीटी, एक ट्रीटी साइन किया गया था जिसमें बहुत सारे कंट्रीज ने भाग लिया था उसके अंदर, तो वो एक उसके तहत जो है हम अलग-अलग कंट्रीज में जो है पेटेंट कर सकते हैं। जैसे कि हमारा ऑस्ट्रेलियन पेटेंट है हमारा, तो हमने ऑस्ट्रेलिया में जाके वहां पेटेंट किया। तो दिस इज टू द पीसीटी एप्लीकेशन, पीसीटी नेशनल फेस एप्लीकेशन। उसके अंदर भी नेशनलाइज लेवल पे इंडिया में दूसरे और पर इंडिया में करना पड़ता है, फिर दूसरी तरफ हमको करना है तो वो भी एप्लीकेशन फॉर एडिशनल एप्लीकेशन, एडिशनल पेटेंट। एडिशनल पेटेंट मींस आपका पेटेंट एक एक्सिस्ट है, उसके अंदर हमने और क्या ऐड किया है और कुछ नया आपने क्रिएटिव बनाया है, तो वो एडिशनल एप्लीकेशन में आए। तो ये एप्लीकेशन सब अलग अलग है। हमको जो एप्लीकेशन फाइल करना है पेटेंट के लिए, तो फाइलिंग स्टार्ट बाय सिलेक्टिंग द एप्लीकेशन। सो वी स्टार्ट फ्रॉम द सिलेक्शन। Convention application, again the treaty which is signed, convention countries, it is called as convention countries. Okay, 142 countries are there. Okay, so all we can have the filing. Patent process work through law and regulation. हम जो भी काम कर रहे हैं, जो भी फाइलिंग कर रहे हैं, जो भी हम इनपुट दे रहे हैं गवर्नमेंट को, इट इज थ्रू द लीगल एस्पेक्ट। हमको फॉलो करना पड़ता है एक्ट, दैट इज पेटेंट एक्ट 1970, amendments in 1999, 2002 and 2005. Amendment means the changes or additions which are occurring in this patent law. Okay, so that and patent rule 2003, amendment in 2005 and 6. The rules and regulations we have to follow. Salient features of Indian Patent Act 1970. अब ये इंडियन पेटेंट एक्ट तो बहुत बड़ा है, आपको चाहिए तो मैं शेयर भी कर सकता हूँ आपको ग्रुप पे। बट साइलेंट फीचर्स क्या है, इसके अंदर क्या बोला गया है, वो एक मोटी मोटी चीजें क्यों है। बोथ प्रोडक्ट एंड प्रोसेस पेटेंट प्रोवाइडेड। एक्ट बोल रहा है कि प्रोडक्ट और प्रोसेस पेटेंट आप कर सकते हो इसमें। टर्म ऑफ पेटेंट इज 20 इयर्स, ये लीगल है, इसके अंदर एक्ट में है। Examination or request, हम जब फाइल करते हैं, it goes to the examination. All this we will see in the filing process. Both pre-grant and post-grant opposition. आप जब पब्लिक के सामने आपका पेटेंट गवर्नमेंट ऑफ इंडिया के पेटेंट वेबसाइट पे डाला जाता है, पब्लिश होता है जर्नल में, इट इज ओपन टू ऑल, पूरी वर्ल्ड के लिए, पूरे इंडिया के लिए ओपन होता है, कोई भी देख सकता है, आप भी देख सकते हो। अभी भी आप जाओगे पेटेंट के साइट के ऊपर IPR-Patents पे, तो आपको जर्नल्स वगैरह सब दिखेंगे, आप उसमें देख सकते हो कि लोग कैसे पेटेंट कर रहे हैं इसके अंदर। ओके, सो उसके लिए आपका जब पेटेंट अवेलेबल रहता है, कुछ अपोजिशन आया कि मैंने भी इस तरह का फाइल किया है, तो अपोजिशन ऑनलाइन फाइल करना पड़ता है अपोजिशन मेंबर को भी, तो वो गवर्नमेंट के ऑफिस में जाता है, आईटी के ऑफिस में जाता है, दे चेक एंड देन दे रियली इट इज देयर, it is disqualified as. Okay. Fast track mechanism for disposal of appeals, जल्दी जल्दी उसका ये होता है, अपने कोर्ट के जैसा नहीं चलता रहता है महीनों सालों इस तरह से। Provision for protection of biodiversity and traditional knowledge, publication of publication after 18 months with facility for early publication. ये हाईलाइट है गवर्नमेंट की तरफ से कि पेटेंट जो है पब्लिश किया जाता है, जैसे कि आप रिसर्च पेपर लिखते हो, ठीक है, और जर्नल को सेंड करते हो, तो वो प्रूफ में जाता है, चेकिंग में जाता है, किसी नेटरी के पास जाता है, और वो अप्रूव किया तो आपका पेपर जो है पब्लिश हो जाता है। कि लाइक द सेम वे हियर आल्सो 18 मंथ्स 18 महीने लगते हैं पेपर मींस पेटेंट पब्लिश होने नॉर्मली। बट इफ यू वांट अर्ली, कि हमको बहुत जल्दबाजी है, हमारा बहुत इनोवेटिव प्रोडक्ट है, हमको जल्दी से लॉन्च करना है, तो उसके लिए भी प्रोविजन लिखा है गवर्नमेंट ने, अर्ली पब्लिकेशन, उसके लिए अलग से फॉर्म आता है, दैट इज व्हाट वी आर डिस्कसिंग। उसके अलग से फॉर्म आता है, वो जल्दी वाला भरे, जैसे कि पासपोर्ट लेते हैं, तो सारे के पास में होगा वो पासपोर्ट, तो नॉर्मल पासपोर्ट को थोड़ा 40 डेज तक के लगता है, 40 दिन का टाइम लगता है, पर तत्काल में चाहिए आपको जल्दी जाना है बाहर, तो तत्काल का एक ऑप्शन होता है, तो इसमें फॉर्म भरे तो 15 डेज के अंदर आपका आएगा। So this is the facility which is given by patent government of India also, कि आपको जल्दी चाहिए तो अर्ली पब्लिकेशन का फॉर्म भरो, उसका कुछ नॉमिनल फीस होता है ऊपर, वो लेके आपका अर्ली पब्लिकेशन लेके आपको सब्सटेंशियली रिड्यूस टाइमलाइन। टाइमलाइन बहुत इंपॉर्टेंट होता है इसमें, क्योंकि टीडीएस प्रोसेस, बहुत सारे फॉर्म भरना पड़ते हैं, एप्लीकेशन एग्जामिनेशन वगैरह वगैरह, तो वो सब चीजें अभी मिनिमाइज की गई है। पहले के जमाने में बहुत टाइम लगता था, अभी मिनटों में काम हो रहा है और दिनों में काम हो रहा है। ठीक है, this is what the patent process is. What overall we will follow the things like right from inventing something as a start, like कुछ तो भी बनाया है आपने, वहां से checking the patentability through the search कि हमारा पेटेंट हो सकता है क्या, पहले से किसी ने पेटेंट को नहीं किया है, then drafting the पेटेंट एप्लीकेशन, ड्राफ्ट करना होता है, ड्राफ्टिंग के अंदर क्या क्या होना चाहिए, ठीक है, वो भी हम देखेंगे। देन फाइलिंग द एप्लीकेशन, फाइल करने बाद में फिर पब्लिकेशन होता है, फिर एप्लीकेशन चेकिंग होता है, पोस्ट प्री एंड पोस्ट ऑब्जेक्शन कुछ तो नहीं है, और लास्ट में फिर ग्रांट होता है। और एक बार ग्रांट हो गया तो वो दुनिया में कोई नहीं ले सकता, तो आप किसी ने लिया तो आप उस पर कोर्ट केस कर सकते हैं। This is what how to patent this, how to file a patent in India. We will talk about the India. International भी होते हैं patent, वो भी फाइल कर सकते हैं। Patent filing procedure, filing patent office jurisdiction। देखो हमको ऑफिस पहले सेलेक्ट करना पड़ता है। On what basis the jurisdiction is selected, that also we will see in the next slide. Okay, the first criteria you have to select the filing jurisdiction. Secondly, prepare a patent specification, पूरा बनाना पड़ता है, टाइटल क्या है, ऑथर्स कौन कौन है, एब्स्ट्रैक्ट क्या है, पूरा डिटेल डिस्क्रिप्शन वगैरह सब। Prepare the necessary documents and forms. We have to fill the forms now. कि फॉर्म 1 क्या है, फॉर्म 2 क्या है, फॉर्म 26 क्या है, फॉर्म 28 क्या है, फॉर्म 18 क्या है, ये सारे फॉर्म्स पे चलते हैं सब, ये फॉर्म बनेगा, ये फॉर्म बनेगा, उसके हिसाब से फिर आपको आगे चलते रहता है। सबमिशन ऑफ डॉक्यूमेंट फिजिकल और ई फाइलिंग, अब आपने बना लिया सब, अब इसको आप सबमिट कर रहे हो गवर्नमेंट को, तो कैसे करेंगे, मैन्युअली भी कर सकते हो आप, बैंक में लेके जाने का पूरा प्रिंट आउट्स वगैरह सब फॉर्म वगैरह मैन्युअली भर के ऑफिस के ऊपर जाके भरना है, मगर 10% आपको एक्स्ट्रा पे करना पड़ता है, क्योंकि वो जो चेक करेंगे वो भी मैन्युअली करेंगे उसको, वो उसका चार्जेस 10% ज्यादा होता है। ई फाइलिंग, नाउ दिस इज अ टाइम फॉर मॉडर्नाइजेशन टेक्नोलॉजी, छोटे छोटे बच्चे जो है मोबाइल पे जो है ये सारी चीजें अभी चालू है, सो ई फाइलिंग इज अ फैसिलिटी व्हिच इज प्रोवाइडेड बाय द गवर्नमेंट, and I think in the last session of tomorrow's session, one of the speaker has nicely taken online demo of the filing, e-filing कैसे करते हैं, open करके बताया है, so this is the e-filing advantage. Next is follow the patent application process, तो जो process है filing, publication, granting, etc. that way. Okay, so this is all. ओवरव्यू कि पूरी जर्नी के अंदर पेटेंट में क्या क्या होता है। ठीक, फाइलिंग ऑफ पेटेंट से स्टार्ट होता है, हमको फाइल करना पड़ता है पहले पेटेंट, नेक्स्ट पब्लिकेशन ऑफ द पेटेंट, आफ्टर फाइलिंग इट गोस टू द ऑफिस, दे चेक द ओरिजिनलिटी ऑफ योर इन्वेंशन, आफ्टर चेकिंग दे गिव द सर्टिफिकेट ऑफ पब्लिकेशन, इट इज पब्लिश्ड इन द इंडियन जर्नल ऑफ पेटेंट्स, ये ऑनलाइन अवेलेबल है, आप बहुत सारे पेटेंट्स देख सकते हैं। उसके बाद में एग्जामिनेशन ऑफ एप्लीकेशन ऑन द रिक्वेस्ट ऑफ द एप्लीकेंट, द एग्जामिनेशन इज परफॉर्म्ड, उसके लिए भी फॉर्म भरना पड़ता है, हमको एग्जामिनेशन करो इसके लिए, क्योंकि आपको ग्रांट तक के पहुंचना है। ये देखो फाइल करके भी आप रुक जा सकते हैं पेटेंट के अंदर, पब्लिश करके भी रुक जा सकते हैं आप पेटेंट के अंदर, और किसी को कमर्शियलाइज करना है, मार्केट प्लेस का फायदा उठाना है, तो उसको ग्रांट करना जरूरी। तो ग्रांट के लिए आपको एग्जामिनेशन ऑफ एप्लीकेशन का फॉर्म भरना पड़ता है, फिर उसमें कुछ ऑब्जेक्शन नहीं आना किसी का, क्योंकि जो देखते रहते हैं कि मेरे वर्क से रिलेटेड किसी ने कोई पब्लिश तो नहीं किया, तो उसमें कुछ नहीं आया, तो ऑब्जेक्शन नहीं आना। Response to offer section by applicant, pre-grant opposition, grant से पहले कोई opposition आया तो उसका फिर hearing होता है कोर्ट के अंदर, ठीक है, और कुछ नहीं है, हियरिंग है, किसी का कोई ऑब्जेक्शन नहीं है, then it is granted. Grant or rejection, rejection on the basis of opposition, कुछ आया तो भाई रिजेक्ट कर दिया जाता है आपका पेटेंट, और नहीं आया कोई ऑब्जेक्शन, और अच्छा है आपका पेटेंट नया है एकदम फायदेमंद है, इट इज ग्रांटेड टू यू। ओके, ग्रांट का सर्टिफिकेट भी मिलेगा आपको, एक मैंने सैंपल भी रखा है इसको। पोस्ट ग्रांट अपोजिशन, अब आपका ग्रांट भी होगा, उसके बाद में भी किसी का अपोजिशन आया, उसने प्री ग्रांट में नहीं किया, देखा नहीं क्या नहीं, पोस्ट ग्रांट में आया, देन उसके ऊपर कार्रवाई होती है, ये जो भी। नेक्स्ट इज रिन्यूअल ऑफ पेटेंट, अब 20 साल गुजर गए, ठीक है, अब उसको रिन्यूअल करना है, तो दैट इज द प्रोविजन या yearly you have to renew your patent which is granted. Abandonment of the patent, कुछ विवाद की वजह से जो है पेटेंट आपका निकाल दिया जाता है, जो भी चीजें है। रिस्टोरेशन ऑफ पेटेंट, ठीक है, तो रिस्टोरेशन मींस आपने फीस भरना भूल गए, इसका रिन्यूअल फीस, तो उसका कुछ टाइम होता है, उसमें फीस भर के आप फिर से उसको रिवाइव कर सकते हो। तो दिस इज द ओवरऑल व्यू ऑफ पेटेंट प्रोसीजर इन इंडिया, ठीक है, फाइल होता है, पब्लिश होता है, अपोजिशंस कुछ आए तो वो देखा जाता है, फिर लास्ट में ग्रांट होता है, ग्रांट के बाद में वो आपका लाइक दिस। Now the things starting filing as a procedure start, आप देख रहे थे हम कि पेटेंट क्या होता है, क्या चीज पेटेंट की जाती है, क्या चीज पेटेंट नहीं की जा सकती है, कौन सा एक्ट फॉलो करना पड़ता है, उनको सारी चीजें हम देखेंगे, ओवरव्यू लेके आएंगे कि क्या क्या पेटेंट में स्टेप्स होते हैं, ऐसे ही मिल जाता है पेटेंट, ठीक है, तो ये सारी चीजें हमने सीखे। अब यहाँ से प्रोसेस हमारा स्टार्ट होगा। अब आपके पास में इन्वेंशन है, पहला काम आप क्या करोगे, आप खुद चेक करोगे कि इसमें कोई दूसरे ने कोई काम किया है क्या नहीं, ठीक, स्टेट ऑफ द आर्ट सर्च, प्रायर आर्ट सर्च, you can say deployment strategy and pre-filing analysis. To check the novelty of your invention, you go through the Google or any search engine and you check that whether such type of the work has already been done or not. Okay, if your work is novel, no searches will form related to your work. Okay, तो ये पहला काम रहता है कि आपका जो नोवेल्टी है तो वो नया होना चाहिए, और उसका डुप्लीकेशन या अवेलेबिलिटी को दूसरे तरफ नहीं होनी चाहिए, ठीक है, तो ये पहला काम यहाँ से स्टार्ट होता है। नेक्स्ट, पेटेंट फाइलिंग स्टार्ट at the website. Patent work start at official website of Intellectual Property India, ipindia.gov. यहाँ से आपका काम स्टार्ट होता है, ठीक, सो आपको ऑफिशियल वेबसाइट पे जाना है, वहाँ पर पूरा प्रोसीजर, पूरे फॉर्म्स, पूरा सब चीजें अवेलेबल। दिस इज द साइट we have taken. You can go, just you type in the Google also IPR-Patents. This you will get the site, and you can have the patent application, patent publication, patent search, various tabs are there. You can follow it. Now the meaning of applicant or patentee. Okay, हम जो हमारा इन्वेंशन है वो हम फाइल करना चाह रहे हैं, वी आर द इन्वेंटर्स, ओके, और हम खुद फाइल कर रहे हैं itself, okay, so there are categories. An application for the patent for an invention may be made by any of the following persons, either alone or jointly with other persons. True and first inventor, अब हमने पेटेंट इन्वेंशन तैयार किया है या हमारे पास में है, and you are personally going to the patent office and all that, this is called as the first true and first inventor, ये फाइल कर सकता है पेटेंट। सेकंड, ट्रू एंड फर्स्ट इन्वेंटर्स असाइनी, अब आपको नहीं आता है सारी चीजें फाइल करना नहीं आता है, क्योंकि लीगल एस्पेक्ट है, सब चीजें आपको नहीं पता है, ओके, तो यू असाइन सम पर्सन टू डू योर वर्क, एजेंट होते हैं ना, you give some money to them and they do their work, pure work, you can say, of patent filing. Okay. Next is legal representative. Okay, like the agent, that's not yet said. Okay, patent agent. Okay, we'll see the next slide what you mean by the patent agent. Because if you see the process, all these things, okay, you are new. Okay, you find very difficulties which word to be used. Okay, legal language use करना पड़ता है उसके अंदर, कोई खराब लैंग्वेज नहीं यूज करना पड़ता, उसमें भी पेनल्टी है। पेटेंट फाइलिंग के अंदर जब बनाते हो आप, उसमें खराब लैंग्वेज यूज की है तो उसपे भी फाइन। तो आप बोलोगे कि आप हमको तो नहीं आता है ये लीगल लैंग्वेज क्या होगा ये वगैरह वगैरह, ऐसे बहुत सारे लोग खुद ही करते हैं ये सारी चीजें, कुछ एरर्स हैं तो दे, but most of the patents they select the patent agent which is a legal agent for the process. So this is legal representative of the deceased co and first inventor of this assignment. Okay, तो तीन तरीके के लोग जो है वो पेटेंट प्रोसेस स्टार्ट कर ले सकते हैं। फर्स्ट इज को एंड फर्स्ट इन्वेंटरी, को एंड फर्स्ट इन्वेंटर, जैसे कि सेल्फ। दूसरा है कि आपको नहीं आता है, हमने किसी को असाइन किया, क्या आपका बहुत बड़ा हमारा काम। और तीसरा है लीगल रिप्रेजेंटेटिव, दैट इज द पेटेंट एजेंट। हु इज पेटेंट एजेंट? देखो कोर्ट में केस लड़ा जाता है, उसके लिए हम क्या हायर करते हैं?
वकील।
आप खुद भी लड़ सकते हैं, आप सेल्फ भी लड़ सकते हो, मगर आपको नहीं आता है लड़ना कोर्ट केस, तो आप जिसको जानकारी ज्यादा है कोर्ट के लॉस की, हर एक चीज की, तो हम एडवोकेट हायर करते हैं कि आप हमारा केस लड़िए। तो इसके लिए सेम पेटेंट एजेंट, a patent agent has defined under the section 2 and here law of the Patent Act 1970 is a person who has passed Indian patent agent examination and is registered under section 126 of the Indian Patent Act as a patent agent. ये लीगल है, ये लीगल एजेंट है, ठीक है, गवर्नमेंट का है। आप लोग भी दे सकते हो पेटेंट एजेंट का एग्जाम, इट इज अवेलेबल ऑन द वेबसाइट। आपको देना है, पेटेंट एजेंट बनना है अभी कभी आपको, तो आप उसका सिलेबस होता है। मैंने भी एक बार कोशिश करा था देने की, मगर से दूसरी एकेडमिक वर्क से टाइम नहीं मिलता है इधर, तो नहीं हो पाया। तो आप डाउनलोड करो उसका सिलेबस, देखो उसके अंदर क्या क्या है, उसका स्टडी मटेरियल देखो, उसका पेटेंट एग्जाम होता है, वो दोनों क्वालिफाई हो गए तो आपको पेटेंट एजेंट, लीगल पेटेंट एजेंट आप फाइल कर सकते हो पेटेंट, और दूसरों के लोग जो आपके पास आएंगे उनको चार्ज भी कर सकते हो आप पेटेंट के फाइलिंग के लिए। और अभी बहुत सारे पेटेंट एजेंट है मार्केट के अंदर जो अलग अलग वेरिएशन से चार्ज करते हैं पेटेंट का आपका ये करने के लिए। सो दिस इज आल्सो अ एरिया वेयर यू कैन फोकस फॉर योर करियर। आपको पेटेंट एजेंट बनना है तो आप बिल्कुल बन सकते हो। देखो करने वाले के उसके ऊपर है कि आपको करना है तो ये सारी चीजें उसके लिए। पेटेंट एजेंट इज इन्वॉल्व इन ड्राफ्टिंग। आप पेटेंट एजेंट क्या करता है? पेटेंट एजेंट इज इन्वॉल्व इन ड्राफ्टिंग, फाइलिंग एंड प्रोसिक्यूशन ऑफ द पेटेंट एप्लीकेशन बिफोर द कंट्रोलर on behalf of the person who wish to file a patent. Patent agent has authorized by the inventor to act on his behalf by executing power of attorney ministry. We have to fill the form number 26 बॉन्ड पेपर पे हमको देना पड़ता है कि हम ये पेटेंट एजेंट को पूरा इख्तियार दे रहे हैं कि हमारा पेटेंट बनाए और उसको प्रोसेस करे और उसको एग्जीक्यूट करे। ठीक है, तो आपका काम आसान हो गया। जिसको पेटेंट करना खुद नहीं आता है लेकिन हायर द पेटेंट एजेंट, आप उससे बात करके सब चीजें वो खुद करता है। तो खुद फॉर्म नंबर 1 2 5 सब फॉर्म्स भर के आपका डिस्क्रिप्शन, पूरा बैकग्राउंड करेक्शन, स्पेसिफिकेशन, हर एक चीज करके जो है वो आपको देता है। और उसकी फीस चार्ज है, कोई 10,000 लेता है, कोई 20,000 लेता है, कोई 25,000, अलग अलग है। depend. Okay, so this is how I just stated that if you want to become a patent agent, you can become the patent agent. You just have to pass the patent agent exam. Online available है, syllabus है, सब चीजें हैं. Then you can have that enjoyment of the patent agent. आपका एक job हो जाता है, legal job. Okay. Rights of patent agent. ये इसके पास में क्या क्या इख्तियार होते हैं? Right of patent agent are described under section 127. सब patent law से कर रहा है, कोई extra person नहीं है patent agent, सब law के अंदर. To practice before the controller to prepare all the document concept of business and discharge such as function as prescribed connection with any proceeding before the controller under this. Patent agent is authorized to draft, file, prosecute the patent and design application in India and PCT. पेटेंट कॉर्पोरेशन ट्रीटी, वहां पर भी पेटेंट एजेंट आपका काम करते थे. अब आपने पेटेंट की एप्लीकेंट कौन होता है, पेटेंट किसको बोलते हैं वो देखा है. ठीक है, पेटेंट एजेंट का रोल क्या है वो देखा है. ठीक है, स्टेप बाय स्टेप जा रहे हैं, समझ रहे हैं कि प्रोसेस कैसा है पेटेंट का और हमको कैसे फॉलो करना है. उसके बाद में हमको जुरिस्डिक्शन फाइंड आउट करना पड़ता है, सर्च करना. जुरिस्डिक्शन मींस कौन से ऑफिस में आप फाइल करोगे जाके इंडिया में. ठीक, एप्लीकेशन फॉर पेटेंट शैल बी फाइल्ड विद द पेटेंट ऑफिस हैविंग एप्रोप्रिएट जुरिस्डिक्शन. टेरिटोरियल है. टेरिटोरियल मतलब आप जहां रह रहे हो, कौन से एरिया के अंदर आपको फाइल करना. अब पेटेंट ऑफिस इज डिसाइडेड बेस्ड ऑन द फॉलोइंग. अब ये कैसे डिसाइड होगा, तीन चीजें उसके अंदर. पहला, place of residence, domicile or business of the applicant, first mention application in the joint application. मतलब जो पर्सन फाइल करना चाह रहा है वो कहाँ का रहने वाला है, कहाँ पैदा हुआ है, डोमिसाइल है. समझो आप महाराष्ट्र के, तो अपने को कहाँ फाइल करना पड़ेगा, महाराष्ट्र के. आप जाके कश्मीर में ये नहीं कर सकते, फाइल नहीं कर सकते. ठीक है, दिस इज कॉल्ड एज टेरिटोरियल. यहाँ रह रहे हो आप. तो पहला केस क्या है, प्लेस ऑफ रेसिडेंस और डोमिसाइल. ठीक है, नेक्स्ट इज प्लेस फ्रॉम वेयर द इन्वेंशन एक्चुअली ओरिजिनेटेड. ठीक है, दूसरा केस क्या होता है कि जहां से इन्वेंशन निकला है. ठीक, औरंगाबाद है, महाराष्ट्र के एरिया अंदर औरंगाबाद से इन्वेंशन, यू कैन फाइल इन द महाराष्ट्र रीजन ऑर्डर. Last is address for service in India given by the applicant when the applicant has no place of business or domicile in India. Foreign applicant. आप कोई फॉरेन स्टूडेंट आया हुआ है बाहर से औरंगाबाद में पढ़ने के लिए और मानू यूनिवर्सिटी में रजिस्टर्ड एंड यू वांट टू हैव द पेटेंट. ठीक है, तो मानू यूनिवर्सिटी का एप्लीकेशन देगा कि ये स्टूडेंट हमारा पीएचडी का स्टूडेंट है और उसने थीसिस पे किया एंड इज गिवन द राइट टू हैव द पब्लिकेशन. तो वो पेटेंट ऑफिस में जाएगा और वो महाराष्ट्र के इसके अंदर रजिस्टर करके देगा. सो दिस आर क्लॉजेस. ये है एक्ट, उसमें से मीनिंग चीजें निकाल के समझ रहे हैं. टेरिटोरियल जुरिस्डिक्शन किसको आप देख सकते हो कि 4 मेजर टेरिटोरियल जुरिस्डिक्शन से पूरे इंडिया में. फर्स्ट इज मुंबई. Under Mumbai, the state of Maharashtra, Gujarat, Madhya Pradesh, Goa and Chhattisgarh, Union Territories of Daman and Diu, Dadra and Nagar Haveli. ये सारी चीजें जितने भी इन्वेंशन से ये एरिया से, तो वो कहाँ पर करेंगे, मुंबई. मेन हेड ऑफिस इज इन मुंबई. तो ये इतने करेंगे. दूसरा कोई कश्मीर से आके महाराष्ट्र में उसको फाइल करना है वो नहीं कर पाएंगे, उसको कहाँ जाना पड़ेगा, उधर. चेन्नई. Next territorial jurisdiction is Chennai. The state of Andhra, Karnataka, Kerala, Tamil Nadu and Union Territory of Pondicherry and Lakshadweep. ये सारी चीजें चेन्नई. न्यू दिल्ली, state of Haryana, Himachal Pradesh, Jammu and Kashmir, Punjab, Rajasthan, Uttar Pradesh. ये सारी चीजें न्यू दिल्ली. Lastly, Kolkata, the rest of the India जो भी बचा हुआ है वो कोलकाता में. So this is Union Territory head office where the patent work, patent head office and उसके एड्रेसेस भी दिए हैं. तो पढ़ने में तो बहुत ज्यादा टाइम लगेगा. तो इसके एड्रेस के लिए है, फोन नंबर्स, ईमेल आईडी जो है आप इसको। Now we are going towards filing. You have selected the jurisdiction also. Now the next step is file the patent. So manual or e-filing. Manual filing. What do you mean by manual filing? Manual is shall be applicable for application containing up to 30 pages and 10 claims. This is very important to understand that in the patent that pages जो होते हैं जो आप लिख रहे हैं specification तो 30 pages का होना चाहिए, ठीक है? और 10 claim होना चाहिए. Claim means what is the novelty? आपकी क्या खासियत है आपने जो बनाया है? तो 30 पेजेस 10 क्लेम, उसके लिए फीस अलग है. और उससे ज्यादा है आपने बहुत ही अच्छा इन्वेंशन बनाया है और आप बहुत ज्यादा लिखते हैं, ठीक है? बच्चे लिखते हैं ना पेपर के अंदर 10 मार्क्स का क्वेश्चन है तो 2-3 पेज लिखना है तो 6 पेज लिखते हैं, बहुत ज्यादा आता है. तो अब 30 से ज्यादा पेजेस उसने दिया है उसको एक्स्ट्रा चार्ज है, ठीक है? हर एक चीज का if the applicant exceeds 30 pages or claim more than 10 in number, additional fees are given in the first. उससे ज्यादा पैसे देंगे. It may be noted that 10% additional fees shall be payable when the application for the patent and other documents are filed to the physical mode. It is the hard copy format. Already we have discussed earlier itself कि आप physically प्रिंट आउट्स वगैरह लेके पेटेंट ऑफिस के अंदर तो 10% एक्स्ट्रा देना पड़ता है क्योंकि चेकिंग उनको फिजिकली करना पड़ता है, ठीक है? तो उसके एक्स्ट्रा 10% जो कि ई फाइलिंग में नहीं लगता. ई फाइलिंग में कम लगता है. ई फाइलिंग सर्विसेज. अब ई फाइलिंग आपने yesterday you have seen live demo, so we will skip out very fast that new and enhanced feature of the comprehensive e-filing has been provided by the government. Tabs are there. You just open the website, okay, and you follow the instruction. Okay, web-based filing is their system. You will be login digital signature and password based. Okay, password generation is also there. Provision of filing for all categories, etc. It's all the process is in the online mode. Next. So this is we have skipped with the online mode how to file because we have seen live demo also for that. Okay, we directly go to the next slide. That is the fees. What is required? This is tentative fees. Okay, it may differ with the application forms. You can say. So normally, on what payable application for the patent sheet or claim form number 1, natural person 1000. 30 pages, 100 rupees claim. Okay, it is then 200 rupees. Okay, so like this way, 1500 to 1600 is the cost for the patent file. Personally, if we are going to, if you hire the patent agent and all that, 4400 plus 800 like this way. Examination request form number 18 you have to fill. 2500 rupees extra you have to pay after the filing. You can say आपको examination के लिए जाना और कोई अदर पर्सन आपके ऑन बिहाफ जैसे पेटेंट एजेंट वगैरह तो 10,000 पे लगता है. अर्ली पब्लिकेशन रिक्वेस्ट फॉर्म नंबर 9 भरना पड़ता है आपको अर्ली पब्लिकेशन के लिए जल्दी के लिए 2500 एक्स्ट्रा भरना पड़ता है और आप नहीं भरे तो दूसरे जो भर रहे हैं उसको 10,000. So this is tentative, it's not exact, this is tentative. You should have the idea that how much amount I will be requiring for patenting this one. Patent necessary document and forms. Now, as we have stated that patent filing is to the forms. हर चीज के लिए फॉर्म भरना पड़ता है, ठीक है? तो फॉर्म नंबर 1 एप्लीकेशन फॉर ग्रांट ऑफ पेटेंट पूरा ग्रांट करना है आपको तो फॉर्म नंबर 1 भरना पड़ता है. फॉर्म नंबर 2 प्रोविजनल और कंप्लीट स्पेसिफिकेशन खाली पब्लिकेशन होना है आपको और उसका इंफॉर्मेशन देना है फॉर्म 2. फॉर्म 3 स्टेटमेंट एंड अंडरटेकिंग देना पड़ता है कि मेरा ये जो इन्वेंशन है वो खुद का है किसी का लिया, दैट इज अंडरटेकिंग. डिक्लेरेशन एज टू इन्वेंटरशिप मैं डिक्लेयर करता हूं कि ये मेरा इन्वेंशन है किसी और का नहीं है वगैरह. रिक्वेस्ट फॉर पब्लिकेशन पब्लिकेशन अभी पब्लिकेशन जैसा फॉर्म नंबर 9 भरना पड़ता है, उसके बाद वैसे करो तो जल्दी से पब्लिक हो जाए। फॉर्म नंबर 18 रिक्वेस्ट फॉर एग्जामिनेशन ऑफ एप्लीकेशन फॉर पेटेंट। एग्जामिनेशन करवाना है आपको पेटेंट ग्रांट के लिए, तो फॉर्म नंबर 18 भरना पड़ता है। फॉर्म नंबर 26 as we have discussed earlier that an authorization to represent the applicant in the patent office। ये पेटेंट एजेंट आप हायर कर रहे हो जब तो फॉर्म नंबर 16 आपको भरना पड़ता है। 28 to be submitted by small entity or startup। अभी जैसे स्टार्टअप चल रहा है, न्यू स्टार्टअप है, उसका हमको ये देना पड़ता है, प्रूफ देना पड़ता है कि न्यू स्टार्टअप है ना, इट इज रेगुलराइज और कंफर्म यू कैन से, तो उसका अलग से फॉर्म भर के स्टार्टअप के लिए हम दे सकते हैं। Next. Is we form. Now, patent drafting. ये तो बात हुई फॉर्म्स की, अलग अलग फॉर्म्स किसी होते हैं और हमको टाइम टू टाइम फॉर्म्स भरते रहना है। हम एग्जांपल भी देखेंगे कि फॉर्म दिखता कैसा है हमारे बारे में। लाइव हमारा पेटेंट जो पब्लिश हुआ है उसके बारे में केस स्टडी हम लेंगे ऑनलाइन। ओके, सो ड्राफ्टिंग का पेटेंट कि आपके पास इन्वेंशन है, उसके लिए आप ड्राफ्ट कर रहे हो, बना रहे हो, ठीक है, जैसे थीसिस बना दिया वैसे बना रहे हो, तो इसके लिए एलिमेंट्स ऑफ कंप्लीट पेटेंट स्पेसिफिकेशन बोलते हैं इसको। टाइटल होना चाहिए, फील्ड ऑफ इन्वेंशन, समरी, brief description of drawing if it is a drawing done, detailed description of the work, abstract, small summary, claims आपके नया क्या है इसके अंदर, that is the claim, and lastly the drawing sheet is there। okay, so this is drafting। ये सारी चीजें पेटेंट के अंदर होती है, हमको टाइप करना पड़ता है। हमारा पेटेंट लेके हम उसमें देखेंगे कि टाइटल वगैरह किस तरह से हमने डालेंगे। अभी तक के फाइलिंग हो गया, फॉर्मल चेकिंग हो गया, हमारा सब्सटेंशियल एग्जामिनेशन के लिए निकाला है। नेक्स्ट इज पब्लिशिंग। अभी तक के फाइल कर रहे हैं, अब आगे इसके बाद में हमको पब्लिकेशन। पब्लिकेशन ऑफ द पेटेंट एप्लीकेशन, ठीक है, हमने पहले ही कहा है कि आप फाइल करके भी रुक सकते हो, आप पब्लिश करके भी रुक सकते हो। आपको ग्रांट चाहिए लास्ट तक के, तो ग्रांट के लिए पब्लिश होना जरूरी है। सो दिस इज अ वेरी इंपॉर्टेंट स्टेप फॉर पब्लिकेशन ऑफ पेटेंट। पब्लिकेशन मींस व्हाट? इंडियन पेटेंट का जर्नल होता है, उसके अंदर वो पब्लिश होता है, ठीक है, उसके अंदर आपका पब्लिकेशन आता है। पब्लिकेशन का सर्टिफिकेट भी होता है, इसमें आप देखेंगे, तो वो उसको बोलते हैं पब्लिकेशन। So any application for patent is not open to the public before the expiry of 18 months from the date of filing or date of priority whichever is earlier। हमने पहले डिस्कस किया कि आपने पेटेंट फाइल किया तो 18 मंथ्स के तक के जो है किसी मींस इट इज नॉट अवेलेबल इन पब्लिकेशन। 18 मंथ्स गुजर देते हैं इसको, और फिर उसके बाद में कोई ऑब्जेक्शन नहीं आया तो ऑटोमेटिकली आफ्टर 18 मंथ्स योर पेटेंट गेट पब्लिश। ठीक है, तो 18 महीने आपको रुकना पड़ता है फाइल करे बाद में, और उसके इट इज नॉर्मल, ठीक है, नॉर्मल प्रोसीजर ऑर्डिनरी पेटेंट एप्लीकेशन। बट आपको जल्दी चाहिए, जैसे हमने कहा है कि 18 महीने कौन रुकेगा, हमको जल्दी चाहिए, हमारा पीएचडी वाइवा है, हमारा बिजनेस खोलना है, हमको ये लॉन्च करना है प्रोडक्ट मार्केट में अंदर जैसे बना के वगैरह, तो आप at the end of 18 months period after the date of filing or from the date of priority whichever is earlier the application is published in the official journal। ठीक है, आपको जल्दी चाहिए तो आपको फॉर्म भर के जो है 1 महीने के अंदर आप पब्लिकेशन ले सकते हैं। दैट इज ऑन द नेक्स्ट स्लाइड। Again publication is part। Here you can see a request for again publication may be made in form number 9। ये form number 9 होगा इसके लिए, with the prescribed fees of 2,500 of for natural person or 10,000 for legal entity other than the natural person। The request for again publication will be considered if it does not permit no subject matter related to the defense or atomic energy। अगली पब्लिकेशन के अंदर भी देखा जाता है कि ये एटॉमिक से रिलेटेड है या डिफेंस से रिलेटेड तो नहीं है, जो लॉ के अंदर है, दैट इज सी। ओके, there is a request under A about it make the application public within 1 month from the date of such request। एक महीने के अंदर आपको पब्लिकेशन मिल जाता है। तो दो क्राइटेरिया है, एक 18 महीने आपको रुकना है तो आप रुक सकते हैं, आपको जल्दी नहीं है, आपने फाइल कर दिया, ठीक है, वो 18 महीने में ऑटोमेटिकली कोई ऑब्जेक्शन नहीं है तो वो पब्लिश हो जाता है। एंड इफ यू वांट अर्लियर पब्लिकेशन, जल्दी है आपको बहुत, ठीक है, बहुत सारे पीएचडी स्टूडेंट्स हैं, एकेडमिशियंस है, जो क्रेडिट पॉइंट्स और कैश के लिए लगता है और बहुत सारी चीजें होती है, तो आप अर्ली में, तो यू कैन फिल अप फॉर्म नंबर 9 एंड यू कैन टेक विदिन 1 मंथ। उसमें भी देखा जाता है कि चेक किया जाता है कि डिफेंस और इसके इकोनॉमिक एनर्जी से रिलेटेड तो नहीं है, देन इट इज वेरी फास्ट, इट इज जैसे तत्काल का आपने एग्जांपल दिया। पर्टिकुलर्स ऑफ पब्लिकेशन, जब पब्लिश हो जाता है आपका जर्नल के अंदर, तो किस तरह से क्या-क्या उसके अंदर मेंशन होता है। The patent office journal is published on every Friday with the following particulars in respect of the applications। एप्लीकेशन नंबर होता है आपका, कंट्री होगा इसके अंदर, डेट ऑफ फाइलिंग होता है, पब्लिकेशन डेट, टाइटल ऑफ इन्वेंशन, इंटरनेशनल पेटेंट क्लासिफिकेशन कभी है तो वो दिया जाता है, नहीं तो एनए लिख के आता है। हमारे उसमें एनए है क्योंकि हमने इंटरनेशनल उसको अभी आप देखेंगे लाइव इसके अंदर। नेक्स्ट, name and address of the applicant, name of the inventors, जितने भी inventors हैं, एक है, दो है, चार है, पांच है, क्योंकि ग्रुप में काम करते हैं, कोई प्रोसेस पे काम चल रहा है, केमिस्ट्री के अंदर काम चल रहा है, तो पूरे inventors या एक inventor है तो एक का नाम होता है। Reference in respect of the patent of addition, division applications को लिए, abstract, number of pages and claim, ये सब चीजें publication में आपका reflect होता है। So we will see how the publication will be। रिक्वेस्ट फॉर एग्जामिनेशन, आपका अब पब्लिश हुआ, स्टेप बाय स्टेप चल रहे हैं। पहले क्या किया हमने, फाइल की, फिर क्या किए, पब्लिश की। अब पब्लिकेशन के बाद क्या, आपको पेटेंट ग्रांट कराना है, तो ग्रांट के लिए आपको एग्जामिनेशन कराना है आपके एप्लीकेशन का या आपके इन्वेंशन का, तो आपको फॉर्म भरना पड़ता, फॉर्म नंबर 18 कि आपको एग्जामिन करो और इसको ग्रांट के लिए हमें ये करना है, तो एग्जामिनेशन में जाता है, फिर से क्रिटिकल एग्जामिनेशन होगा इसके ऊपर। ओके, तो नेक्स्ट, रिपोर्ट ऑफ एग्जामिनर। अब आपने एग्जामिनेशन पूरा गो थ्रू हुआ, कंट्रोलर ने सब चीजें देखा, विद रिस्पेक्ट टू द लॉ 1970 इंडियन पेटेंट लॉ एक्ट, यू कैन से 1970, उसमें सब चीजें चेक किया, आप कुछ उसमें वायलेशन नहीं है, then it is the report is given to the applicant। Report of examiner, the examiner makes a report after carrying out the detailed examination with respect to the following points: whether the application and specification and other documents related thereto are in accordance with the requirement of the act, acts के थ्रू बनाया गया है, सब चीजें लिखी जाती है, whether there is any lawful ground of objection for the grant, कोई ऑब्जेक्शन तो नहीं आया है इसके ऊपर, वो देखा जाता है। The result of investigation, next, after checking all these points, FER is provided। Just remember FER, first examination report, कि सब चीजें सही है, कोई ऑब्जेक्शन नहीं है, कोई फॉल्ट नहीं है इसके अंदर, it is given to the applicant। Next, after publication and opposition can be filed within 6 months। जब उसको FER दिया जाता है उसके बाद में 6 महीने तक के कोई उसका प्री ऑब्जेक्शन होती है, प्री ग्रांट ऑब्जेक्शन या ऑपोजिशन, ठीक, ग्रांट से पहले फिर से पब्लिक के सामने रखा जाता है, इस पे कोई आपका टिप्पणी तो नहीं है, कोई आपत्ति तो नहीं है, चेक कर लो एक बार। नेक्स्ट, लास्टली उस पे कोई ऑब्जेक्शन नहीं आया, इट इज ग्रांटेड। Okay, finally, the patent is granted as expeditiously as possible when the applicant has no refuse by the controller. पहला केस controller से कोई refusal नहीं है उसके लिए। Second, application has not been found to be in contravention of the provision of the act. Act से हटके कुछ नहीं किया patentee ने। दूसरा clause। तीसरा, on the grant of patent, every patent is allotted. Now grant हो गया, उसके अंदर क्या क्या रहता है grant के उसके अंदर हम देखेंगे लाइक on the grant of patent, every patent is allotted a serial number by the electronical system. Certificate of patent is generated in the prescribed format and an entry in the e-register made simultaneous. जैसे हमने कहा है कि लीगल डॉक्यूमेंट होता है तो सब उसका इलेक्ट्रॉनिक सीरियल नंबर, सर्टिफिकेट, ई-रजिस्टर में उसकी एंट्री सब हो जाता है। नेक्स्ट, so you can see now the grant of the patent, how it looks like. You can see my name is also there while I wrote. If you see the whole granted patent, it is a design patent we have made. We have made for fruit and vegetable quality checking device. ये डिवाइस बनाया है इसके लिए पेटेंट। आप देख सकते हैं ऊपर ओरिजिनल लिखा है और उसका नंबर है 13137। गवर्नमेंट ऑफ इंडिया का स्टैम्प है, डिजाइन नंबर है, डेट है, डिस्क्रिप्शन है, कौन-कौन इन्वेंटर्स है, लास्ट में कंट्रोलर भी साइन। So this is how it look like that grant of patent. Okay, next. Term of patent, as we have discussed earlier also, the term of patent is 20 years. एक बार मिल गया आपको ग्रांट, 20 साल तक कोई इसको हाथ नहीं लगा सकता वो आपके। ठीक है? Application is respected, signing of application in respect of all the patent including. Next. पोस्ट ग्रांट प्रोसीजर। अब आपको ग्रांट हो गया है आपका पेटेंट, देन नेक्स्ट व्हाट? ठीक है, मेंटेनेंस ऑफ पेटेंट एंड आपको रिन्यूअल फीस भरना पड़ता है हर साल। ठीक है, कोई नहीं है, टू पे विद 3 to 6 months फ्रॉम द डेट ऑफ अकॉर्डिंग इन द रजिस्टर। आपको ग्रांट हो गया है तो फिर उसके बाद में दो फीस फॉर फर्स्ट एंड सेकंड ईयर। पहले साल और दूसरे साल कोई फीस नहीं भरना पड़ता, 2 साल आपका patent granted है आपको। there is a you can say incentive by the government. Renewal fees on the yearly basis is required to be paid from 3rd to 20th for keeping the patent in force. तीसरे साल से 20 साल तक के आपको रिन्यूअल फीस उसका भरते जाना पड़ता है। ये पेटेंट को लाइव रखने के लिए, आपका ग्रांटेड पेटेंट को लाइव रखने के लिए। Delay up to 6 months from the due date permission on payment of fees extension of time। 6 महीने तक के आपने नहीं भी भरा तो आप फीस भर के जो है इसको डिलीवर कर सकते हैं। Patent lapses if renewal fees is not paid within the prescribed period। आपने फीस नहीं भरा उसका तो आपका पेटेंट लैप्स होगा, मतलब गवर्नमेंट उसका जो आपको गारंटी का ये दिया है, हक दिया है, वो छीन लिया जाएगा क्योंकि आपने रिन्यूअल फीस नहीं भरा है। ठीक है, so this is important that after granting also you have to renew your patent.
And नेटवर्क इशू स्क्रीन शेयर हो वो अंदर से कुछ कर रहा है मैम अंदर से अंदर का क्लोज कीजिए वो अंदर से क्लोज करना पड़ेगा सही है शेयर शेयर हो रहा है अंदर से ओपन कर दिया है ओपन कर दिया दूसरा ब्राउजर खोल दिया मैम अंदर से क्लोज कीजिए ना उसको आप क्लोज कीजिए ज्वाइन नहीं करना क्लोज कर दीजिए ये हटाओ सर का लाइव चल रहा है सर लाइव चल रहा है सर कंटिन्यू कर सकते हैं
सर आप कंटिन्यू करें
कंटिन्यू कर सकते हैं तो मिरर अंदर से कर देंगे अंदर से कैसे करेंगे कंटिन्यू प्रिपरेशन बहुत अच्छा करे सर बहुत सेंस सर बहुत अच्छा हो सर बड़े 70 तक स्लाइड है 53 चल रहा है इधर से चल रहा है वो स्क्रीन उन्होंने इसका स्क्रीन वहाँ पे शेयर करना है अंदर से हाँ ये स्क्रीन वहाँ पे शेयर करने बोली उनको ये वाला मैम का ज्वाइन टू ऑल अभी आया नहीं, आया नहीं। ये वाला स्क्रीन वहाँ मिरर हो रहा था अंदर से पीपीटी के जरिए, क्योंकि वहाँ पे है नजरिया में, तो ये इस मिरर को वहाँ पे करना है डिस्प्ले आया दीजिए, आया नहीं, नहीं ये आ गया, उनका नेटवर्क चला गया था, क्योंकि वो इस डिस्प्ले को वो पता नहीं कहाँ घूम रहा है, वहाँ पे बैठने बोलिए स्टाफ है क्या। सर वो अपना स्क्रीन फुल स्क्रीन क्यों नहीं कर रहा है मास्टर, हो जाएगा ना अभी कैसे ये ना 6640 ये फिर इसको मान करके वो डिस्प्ले आ रहा है, उनको बोले फुल पे करने के लिए उसमें तो आप गोना पे क्लिक करने से तभी कैसे किया था। मैं उनको बोल सर सर स्टार्ट कर सकते हैं
सर स्टार्ट कर सकते
Okay. For the technical glitches. So, verily, the process which we are following for the patent application, that is from filing, we have seen to the publication, okay, to the grant, and the term for the grant is 20 years, as we have already discussed. Next slide. So we have seen the restoration of the patent also, and here is the summary what we have seen up till now for the presentation. That is patent grant procedure overall, and we have now the case study, some live forms, and one of my research project which we have already published. That we will see live on the case study. Next slide. This is the fees paid to the. We start with the fees paid to the patent office. So this is how fees paid received look like. It is we have paid 1,600 rupees for filing our patent on the topic. See the topic transdermal patches. Formulation comprising of extract of Momotica chirantia. Momotica chirantia, as we use in the food also, that is Karela. Botanical name is Momotica chirantia. So, what we propose in this patent, it is my informed student, Farin Fatima. She has worked under my guidance, and we have made a novel transdermal patch. As you know that Karela is used for diabetes mainly. In the diabetic person also use the Karela, Momotica chirantia. So it is कड़वा होता है, ठीक है? तो हमने वो कॉन्सेप्ट लिया है कि कड़वा होने की वजह से लोग उसको लेते नहीं हैं, भाजी वगैरह बनाते हैं, सबको मालूम है, ठीक है? मगर जूस उसका कड़वा होने की वजह से पूरा मुंह कड़वा हो जाता है हमारा, उसकी वजह से लोग ज्यादा लेते हैं। तो हमने कॉन्सेप्ट सोचा है कि उसको हम बाहर से दें, तो हमने उसका एक्सट्रैक्ट ये किया और उसका ट्रांसडर्मल पैच बनाया। ट्रांसडर्मल पैच बोले तो एक फॉर्मुलेशन प्रोसेस फॉर्म होता है जो कि हम स्किन पे लगा देते हैं और स्किन में से जो है वो एक्सट्रैक्ट जो है वो एब्जॉर्ब करता है, तो ब्लड में आता है, पूरे बॉडी में जो है वो सर्कुलेट होता है, तो उसके वजह से ब्लड शुगर डायबिटीज मेलिटस शुगर जो है वो कम होता है। दैट इज आवर स्टडी। उसके लिए हमने ह्यूमन स्किन वगैरह सब यूज किया है इसके अंदर। सो वी हैव patented this transdermal patch of Momotica chirantia, that is Karela. So this is what we have filed, and we have got the publication also on this. So this is the fees received first. Second, here we make the specification, overall specification. हमने क्या क्या उसके अंदर लिखा है या क्या क्या दिया है। तो this is overall summary, patent specification, title, period of invention, background, summary, abstract, claims, क्या क्या किया है हमने इसमें, आपको लाइव लिखेगा। Next, this is form 2, all the specification. If you see, we have to give this information. The title of invention. Okay, we have to give the title first. So what we have given the title, transdermal patch formulation comprising extract of Momotica chirantia, Karela. Okay, next, name of applicant. हम दो applicant थे, मेरी student थी फरीन फातिमा, उसका नाम हमने फर्स्ट डाले मिस फरीन फातिमा। नेक्स्ट डॉक्टर मिर्जा, ये हमारा दो ही लोग थे। नेक्स्ट इज नेशनलिटी। दिस ऑल फॉर्म के अंदर हमने जो भी फॉर्म डिस्कस किया है ना, फॉर्म 2 भरना पड़ता है, फॉर्म ये भरना पड़ता है, ये फॉर्म्स के अंदर ये लिखना पड़ता है। दिस nationality, second example, Indian, we are Indians. Next is address, आपका क्या एड्रेस दिया ऑफिशियल, तो हमारे कॉलेज का नाम इसमें आप देख सकते हैं, वाई कॉलेज ऑफ फार्मेसी, फार्मास्यूटिकल केमिस्ट्री डिपार्टमेंट. Next, preamble to the description. Preamble means introduction. Okay. The present invention relate to the transdermal patch formulation comprising the extract of Momotica shirantsia. ये हमने preamble को. Next. Now this is what the description. Okay. कि हमने क्या किया इसके अंदर, कैसे बनाया, स्टेप बाय स्टेप इसके अंदर हमने फॉलो किया. Detailed description of the invention भी हमने इसमें put up here. Next. Now these are the claims which have forwarded. 8 claims हमने किए हैं इसके अंदर, ठीक है. We have to claim the invention. कि आपका नया क्या है इसमें, novelty क्या है, आपको बताना पड़ता है गवर्नमेंट को. So first, transdermal formulation comprising extract of Momotica shirantsia. ये हमारा first claim. Second, formulation claim first wherein formulation is used externally. External के लिए बनाया है, ठीक है. Next is formulation claim. Formulation further comprises pharmaceutical acceptable inert excipient. तो मतलब उसके अंदर सारी चीजें जो भी ऐड की है वो हार्मफुल नहीं है, it is beneficial. फिर इसके बाद में डायबिटीज मेलिटस 2 के लिए यूज होता है. नेक्स्ट ये सारे क्लेम्स हमको देना पड़ता है. ये एक एग्जांपल बता रहे हैं हम आपको, एक डेमो बता रहे हैं कि किस तरह से क्लेम्स हमको देना पड़ता है हमारी इन्वेंशन एंड डिजिटली साइन. नेक्स्ट, एब्स्ट्रैक्ट आपके इन्वेंशन का 3 लाइन का एब्स्ट्रैक्ट दिया है. प्रेजेंट इन्वेंशन रिलेट टू द transdermal patch formulation comprising of the extract of Momotica shirantsia and a process of preparation thereon. Next, this is form number 26. हमने बोला है ना हम पेटेंट एजेंट आया करके हम, और वो पेटेंट एजेंट जो है आपका पेटेंट बनाता है, तो हमने एक पेटेंट एजेंट से क्लेम करवाया था. तो इसके ऑन पेपर पे जो है फॉर्म नंबर 26 जो है, दिस इज द मैटर व्हिच वी हैव. नेक्स्ट, दिस इज ऑथराइजेशन लेटर, ठीक है. दोनों का साइन है हमारा, साइन डिजिटल साइन हर उस पे लगता है. तो दिस इज यू कैन सी वी हैव बोथ हैव साइन फॉर having the patent agent. Next, this is publication what we got. जैसे लगता है पब्लिकेशन, पेटेंट जर्नल के अंदर जो पब्लिश होता है इस तरह से लगता है. हमने जो भी डिस्कस किया है कि इसमें कंट्री का नाम होता है, इसमें पब्लिकेशन डेट होता है, इसमें क्लेम होता है, आप लोग सब देख सकते हैं इसके अंदर. दिस इज लाइक पेटेंट, आप नाम भी देख सकते हो एप्लीकेंट के, इन्वेंटर्स के, आप इसमें क्लेम्स भी देख सकते हो, पेटेंट्स भी देख सकते हो कितने. दिस आर द इंपॉर्टेंट एस्पेक्ट कि पेटेंट कितना कैसा है पब्लिश होने के बाद. नेक्स्ट, now overall review stages what we have seen in this presentation, from filing of application to the provisional and complete application, publication of application, request for examination, examination issue, FER. Okay, आपको पता होगा FER क्या है, अभी सुने आपने. फर्स्ट एग्जामिनेशन रिपोर्ट, राइट ऑफ पेटेंट, और उसके बाद में आगे की चीज. नेक्स्ट, दिस इज the last slides. Benefits of patent and advice. My personal advice to all, because teachers are also there, researchers are also there, students are also there. So take the benefit of patent. Take your invention. Do the novelty work. Okay. So here some many advantages are there. Some have taken protecting your original research work throughout the seminars and workshop presentations we are looking at, them protecting your work. Okay. Second, taking patent publication benefit by the research scholars in PhD will justify the novelty and quality of work. Many PhD students, they are patenting their work. Even under my guidance, patents are there for the students, those who are doing PhD undergrad. So this reflects your novelty. This is the backup, you can say, for your PhD work. So those who are doing the doctorates, you can plan for the patenting of your work. Next is for securing the academic points for the teachers. if you do the patent along with your research students, okay, so you get the credit points for the patents. Increasing in academic performance indicator (API score), which is very important in the academics, teachers knows better. Okay, so for them it's very helpful to increase the API score. Education is academic promotion through CAS, career advancement scheme. Okay, if you have in your academic career through CAS, you want the promotions and all that, it will be very beneficial patents there. Increasing research quality and resume update through the patented work, okay, new work, model work, you increase your quality of and your resume update and your value also, because you are having the patents which are other people are not having like this. To avoid duplication of your invented work, this of course your protection. आपका खुद का जो चीज है वो दूसरे ने उसका गलत इस्तेमाल नहीं करना है. Increasing the value of yourself and organization in organization which you have affiliated, you are working, the value of that organization also increases because now the of NAC accreditation, NPA, NRF ranking and all that, it is very helpful in that particular. Offering your patent to sell and earn from them. You can sell your patent with a handsome money, you can say, or royalty you can say, and you can get आप बेच सकते हो आपका पेटेंट आपको जितने में भी बेचना है जो लेने के लिए तैयार है 10 लाख 25 लाख 50 लाख जो भी. So this is the benefit of the patent. Commercializing through patent by opening new business or startups. आपका पेटेंट है आपके पास न्यू इन्वेंशन है आप आपका खुद का स्टार्टअप खोल सकते हैं जैसे कि अदरक का एग्जांपल है जस्ट एक एग्जांपल ये कि अदरक को ऑयल बेचना है तो बहुत मांग है इसके अभी मार्केट के अंदर आपको जाना है किसी के दिमाग में कुछ है तो बिल्कुल पेटेंट पर हो लाइसेंस द पेटेंट एंड गेट द रॉयल्टी अप टू 20%. आप किसी कंपनी को आप कोलैबोरेशन में काम कर रहे हो आपका पेटेंट कोई लेने के लिए तैयार है कंपनी आपका जो वो प्रोडक्ट जो बेचेगा उसमें जो 20% आपको शेयर मिलेगा. समझो 1 करोड़ रुपए का टर्नओवर है एक महीने का एक कंपनी का तो आपको कितने मिलेंगे 20% लगाओ 20 लाख रुपए. इसको बोलते हैं एक महीने का सेल. ये है पेटेंट की ताकत ये है पेटेंट का इंपॉर्टेंस ये जानो students, especially to the students. Higher monetary return is the patent infringement detected. कहाँ से भी कमा सकते हो आप पेटेंट. आपका वायलेशन हुआ है पेटेंट किसी ने चुरा लिया है ठीक है तो आप उसके कोर्ट केस करके उससे रॉयल्टी वसूल कर सकते हो कि तुमने क्यों लिया. कोर्ट खुद बोलता है कि इनको आप रॉयल्टी रॉयल्टी डिपेंड अपॉन द कोर्ट मैटर तो आपको उससे भी पैसा मिलता है किसी ने आपका पेटेंट चुरा लिया. Donating your patent to the institute and organization may reduce helpful for the tax liabilities also. Our organizations, universities को भी दे सकते हैं. Anti-fraud you can create a company for your patent product and avoid plagiarism. Okay. Anti-frauding भी कर सकते हो आप plagiarism के अंदर भी आप इसको ये ले सकते हो. Helpful in increasing the NAC and university ranking etc. So this is personal advice. What I am thinking I could just put for the advice to all. It is not taken from anywhere. So meaning is to say that I am very much promoting to the patenting and all of the students, teachers and researchers. I request you to just put your hand in the patenting and literally those who are planning for businesses, startups. And all that you earn a huge money from this patents. Okay, so this is the strength of patents. Conclusion: we hope you have understood. I will not read all of the things. Hope this small you can say the presentation might have cleared the many doubts about the patents and you can understand some things regarding with respect to the filing to the grant of the patent. What are the different things which we have to follow? Okay, and we can avail the benefits of the patents. I stop here and the forum is open for the discussion. If anyone is having any question in the mind related to this just now what we have presented. You can clearly. So we can ask the questions now.
ये तमाम क्वेश्चन ऑडियंस और पार्टिसिपेंट्स की तरफ से हैं। हमरुल खुदा एक पार्टिसिपेंट जो है इनकी तरफ से और दीगर 5 लोगों की तरफ से एक सवाल आया है कि अगर हमारा पेटेंट एजेंट या फिर हमारा जो डिजाइन है उसको लेके हम किसी इन्वेस्टर के पास गए हैं क्योंकि वो बहुत ज्यादा खर्चीला है, तो उसने हमारा आइडिया पेटेंट से पहले खुद के नाम से भी पेटेंट करा लिया, तो इस केस में क्या करें?
देखिए इसमें क्या होता है, जैसे हमने अभी बार बार डिस्कस करे कि पब्लिकेशन, अभी पब्लिकेशन आपको रह नहीं जा रहा है, 1 महीने के अंदर ही करेंगे, आपको 18 महीने रुक नहीं सकते हैं। तो पहला काम ये करना है हमने कि हमारे पास जो आइडिया है उसको पेटेंट कर देना, फाइल कर देना, फिर उसके पास जाना जो भी पब्लिकेशन ग्रांट हुए बाद में। एक्चुअली द प्रोसेस इज यू गो आफ्टर योर ग्रांट। आपको ग्रांट हो गया, आपके नाम पे पेटेंट, आपको सर्टिफिकेट मिल गया, जैसे कि हमने अभी सर्टिफिकेट देखे, हम लिख सकते हैं फूड और फ्रूट्स की जो क्वालिटी डिवाइस है हम किसी भी कंपनी को बेच सकते हो। तो आपके पास में ग्रांट का सर्टिफिकेट है जब ही आप चाहिए, पहले मत चाहिए, क्योंकि उसके पास में आप डिस्कस करेंगे तो वो आपके आइडिया चुरा लेगा। तो इसलिए उसके पहले नहीं जाना चाहिए, अपने को लीगल एस्पेक्ट पूरा करे बाद में यू कैन अप्रोच एंड यू कैन हैव द डील आफ्टर।
सर नेक्स्ट क्वेश्चन अबू हमजा और एक पार्टिसिपेंट की तरफ से है कि अगर किसी ने बगैर इजाजत किसी पेटेंट की चोरी की है तो उसको किस तरह की सजा तजवीज है हमारे कानून में हिंदुस्तान के, और क्या मतलब उस पर तसल्ली बख्श जवाब चाहते हैं, सजा क्या है?
गुड क्वेश्चन। अभी in the presentation we have seen that a patent infringement, it is in the law, Indian Patent Law 1970. In the court matter, if any found like this type of the activity, violation activity, you file the court case against him, and many court cases are there. You can see in the Google. Okay, big companies. You have seen the various previous presentations also, the infringement. Okay, so generally there is the imprisonment, jail हो सकती है, या फिर उस जेल के साथ में उसको पेनल्टी भी देना पड़ेगा, अमाउंट देना पड़ेगा, एंड डिपेंड्स ऑन हाउ व्हाट टाइप ऑफ द इंफ्रिंजमेंट अकर्स। तो अलग अलग सजा रहती है इसके अंदर, जेल से लेके तो आपको उसका ये भी देना पड़ेगा, रॉयल्टी भी देना पड़ेगी या पेनल्टी भी देना पड़ेगी। कितने लाख हो सकती है, 1 लाख हो सकती है, 2 लाख हो सकती है।
एक और पार्टिसिपेंट परवेज आलम ने पूछा है सर कि समाज के लिए जो चीज नुकसानदेह है उनका पेटेंट नहीं हो सकता, लेकिन न्यूक्लियर बॉम्ब या न्यूक्लियर टेक्नोलॉजी जो है इसका पेटेंट है, हाइड्रोजन बॉम्ब है, तो इसके मुताबिक पूछना चाहते हैं।
ये क्वेश्चन कैसा है, डिफेंस रिलेटेड है ऑफ द कंट्री। हमने अभी कहा है कि डिफेंस और एटॉमिक एनर्जी से रिलेटेड पेटेंट नहीं होता है, मगर कंट्री की प्रोटेक्शन के जो रूल्स एंड रेगुलेशंस है जो मिनिस्ट्री लेवल पे होते हैं, तो वो लोग, वो उसका अलग ये होता है, उसके अंदर वो लोग अपने डिफेंस के लिए जो है वो बनाया जाता है, तो उसका पेटेंट ये जो प्रोसेस है पेटेंट का उसमें नहीं करते।
थैंक यू सर। यहाँ पर डॉक्टर मिर्जा खालिद बेग की पेशकश मुकम्मल होती है, जिन्होंने पेटेंट एप्लीकेशन प्रोसेस फ्रॉम फाइलिंग टू ग्रांट ऑफ पेटेंट पर अपनी जो प्रेजेंटेशन था वो किया। अब मैं मिसेस सिद्दीकी उस्मा तहसीन मैम को मदद करती हूँ कि वो आए और सारे दर्शकों को पेश करें। I once again welcome Professor Mohammad Sahir Khan sir, Principal MANUU City Istanbul, for giving his reflection on this session. He will be joining us online.
देखिए सर हो गया आपका। सर आप ऑन कीजिए आपका, आपकी तरफ से ही होगा सर, मैंने आपको पोस्ट किया है ना वीडियो। आप अपनी तरफ से ऑन कीजिए सर, यहाँ से ऑन है सहील अहमद खान। हेलो
और जितने भी हाज़रीन हैं, आज का जो टॉपिक है इंटेलेक्चुअल प्रॉपर्टी राइट्स, पेटेंट्स एंड डिजाइन फिल्म, ये जनाब डॉक्टर मिर्जा शाहिद साहब ने डिस्कस किया। मैं इसका पूरे सेशन में रहा और बहुत अच्छे से इसको सुनता रहा और इसमें वाकई में ये जबरदस्त लेक्चर था। इसमें जो सर ने पेटेंट रिगार्ड प्रोसीजर के बारे में डिस्कशन किया, बहुत अच्छा था। और यानी इस लेक्चर का अगर देखें तो बीएड स्टूडेंट से लेके एमएड, पीएचडी, चीफ असिस्टेंट प्रोफेसर, एसोसिएट प्रोफेसर, प्रोफेसर सबके लिए फायदे होंगे। इसमें सर ने मेन पॉइंट जो बहुत ही इम्पोर्टेंट पॉइंट्स हैं, जैसे पेटेंट नेसेसरी डॉक्यूमेंट्स एंड फॉर्म्स, क्या क्या डॉक्यूमेंट्स होंगे, क्या क्या फॉर्म्स लगेंगे, वाकई सभी को मालूम होना चाहिए। ये लेक्चर के दौरान किसी ने कहा कि भेजा कि हमें स्लाइड्स शेयर कर दे तो बेहतर होगा। बहुत ही शानदार लेक्चर था। इसमें एलिमेंट्स ऑफ कंप्लीट पेटेंट स्पेसिफिकेशन बहुत जरूरी है सबको जानना। इसके बाद आपने जो बताया कि पर्टिकुलर्स ऑफ पब्लिकेशंस, उसमें क्या क्या होना चाहिए, रिक्वेस्ट फॉर एग्जामिनेशन, रिपोर्ट ऑफ एग्जामिनर्स, इश्यूएंस ऑफ फर्स्ट एग्जामिनेशन और प्री ग्रांट अपोजिशन, जो सर ने बताया बड़ा जबरदस्त है कि किसी कोई कहीं अगर मसला है तो उसमें प्री ग्रांट अपोजिशन उसमें अपना रेस कर सकता है, बता सकता है। इस तरीके से अगर हम देखें तो सर ने बहुत शानदार लेक्चर दिया और सबके लिए फायदेमंद है। बीएड के स्टूडेंट के लिए पहले से जान जाएंगे, एमएड के स्टूडेंट जो प्रोजेक्ट करते हैं उनको भी इसके बारे में मालूमात हो जाएगी और इसके बारे में आगे करवाएगा। फिर जो रिसर्च कर रहे हैं, रिसर्च स्कॉलर्स के लिए भी और सुपरवाइजर्स के लिए भी, जैसे हम लोग हैं तो हम लोगों के लिए भी बहुत ही फायदेमंद लेक्चर था। इस तरीके से हम इसको अगर शॉर्ट में गए हैं तो ये कहें कि सर का जो लेक्चर था वो आज के दौरे हाजिर में और आज जो पेटेंट और ये डिजाइन फिलिंग ये सब के बारे में जो बारीक बीनियां हैं उस पर सर ने बहुत अच्छी रोशनी डाली। जो उसकी जो छोटी छोटी मालूमात की वजह से परेशानियां आ जाती हैं, सबसे हम जाहिर है कि हमें तमाम चीजों के बारे में नॉलेज और ये तमाम लोग इससे मुस्तफीद होंगे। और मैं मुबारकबाद देता हूँ शहना को कि आपने बहुत अच्छा लेक्चर करवाया और उम्मीद है कि ऐसे लेक्चर होते रहेंगे, हम भी इससे फायदा उठाएंगे और आपके लिए। इसी के साथ में मेरा दाखिल के हमने शहनाज मैडम को से गुजारिश करूंगा कि आप चेक करें।
Thanks for sir. I express my thanks to Dr. Mirza Shahid Beg sir for an informative and engaging session. Just like sir's calm demeanor, his presentation has also been filled with simplicity. Simplicity in the sense filled with clarity, conceptual clarity. I sincerely thank Professor Mohammed Saeed Khan sir for his invaluable insight and reflection into the topic of this session. Thank you, sir. Thank you.